Can I just say something about Andrea?
Well, hey, everybody. Thank you so much for joining me today. A little bit spur of the moment. I had other plans for my day, but they involved ladders and chainsaws and things that do not go well with high winds. So I just decided instead, what the heck? Why not? If I'm going to be looking at stuff, maybe making videos, whatever. Hey, I'm gonna be watching this closing argument here either way. So why not just go ahead and invite people in to watch it with me and to talk about some of the digging I've been doing into Michael Burt. So those of you who are on the Substack, you know I'm a huge Richard Novak fangirl. I did a write up of Richard Novak. Oh gosh, it's a few weeks ago now, I guess. Yeah, back at the beginning of April. And there's a lot of reasons why I want to get to know this defense team a little bit more. Kathy Nestor kind of gets all the attention. She's been sort of the most high profile one recently. She's in court right now. Those of you who are not currently watching Corey Richens getting sentenced, Kathy Nestor is over there today. And so I know there's been a lot of people have a lot of opinions about Kathy, and I'm still catching up on her. I want to go back and watch some of the trial and some of what she contributed and stuff to get a sense of her, just how she performs. But I got to say, by way of background alone, she's no slouch. That said, she's left in the dust, really, by both Mr. Novak and Mr. Burt. So Mr. Novak, he's the guy who's like, he's in the prime of his career right now. He started practicing law, I want to say in about 1992. So he's been doing it for quite a number of years. He has 800 plus, 836, I believe, cases on Pacer. Okay, this is a massive, massive record of his work, which has primarily been in federal court as a federal public defender, and then later as a private, what they call a CJA lawyer, Criminal Justice Act, which is like you're a public defender, you're appointed to cases, you get the public defender pay rate, but you are still a private lawyer. You're just doing it on a contract basis. So he's done that for many, many, many years. He's got the real federal expertise on the whole team. Michael Burt has a little bit of a different background because he came up through the San Francisco Public Defender's Office and has spent much more of his career at the state court level. Now, he does have a federal court record. He's got like 36 cases, I think, in Pacer. So it's not unfamiliar to him, but it's just not where he has spent the majority of his work. So a lot of reason to be interested in these guys, but I got to tell you, one of the main reasons why is because I know there's a lot of questions about the case and a lot of theories about the case, and we're back with the waters being stirred about the Discord messages are fake because the defense said they used the words the time of his arrest, the night of his arrest in a motion, and it must mean something specific. Okay, and nothing wrong with asking questions, right? Nothing wrong with asking questions. But at a certain point, you have to consider counter questions as well. And a big counter question is, if there's supposedly evidence that these Discord messages were fraudulently created and are being fraudulently offered by the state in the preliminary hearing, that at some point the defense is going to mention that. Quite frankly, would have expected this pretty soon in the process. Any number of ways. I mean, we saw Kathy Nestor at one of the hearings find a way to just drop in that, oh, did you know that there were five, it was a mixture of five contributors on the DNA sample recovered from the scene. Oh, that was, that's a way to like drop potentially exculpatory-ish information into the public record over the course of the hearing. I do find that, of course, interesting. I've talked about it and kind of what that means from a text standpoint and so forth. But not a peep whatsoever about, why there might be some fraud being perpetrated on the court here. So there's, one of two ways this is likely going to go. The one where, the defense team is kind of the authority on the defense and like what it is, and are the ones who kind of know if there's anything to work with on an issue or not. Or we have the mindset of they're not on his side. They're working against him. Common kind of go to. And in fairness, can't say that there's never been a case of a defense lawyer doing a bad job or not liking their client, throwing them under the bus or anything like that. But I think you get a little bit of a sense of what kind of defense the attorneys are going to put on by getting a sense of how they've done it in the past. And, one of the reasons I have like almost zero concern about the effectiveness of counsel that have been appointed to Tyler Robinson. And it's largely on the strength of Richard Novak and Michael Burt. So Richard Novak talked about before in the Substack piece and focused a lot on this one particular case he did, U.S. versus Guerrero, which was a death penalty case down in California, litigated it for 6 years pre-trial. Ultimately, just talked about kind of some of the roads that he went down, how he litigated the case, like the persistence that a dedicated, lifelong, hasn't been capital defense for his whole career, but has been criminal defense his entire career. Just the way that they will bring any and everything to bear to get a benefit for their client, and the extremely good outcome he was able to get for his client in that case. So that's Mr. Novak. That's why I'm a big fan of him. But Mr. Burt, I haven't really talked about Mr. Burt yet. And so when they first joined the defense team, what kind of got attention about Mr. Burt joining the team is that before Kathy Nestor, other than Kathy Nestor, whose sort of notoriety, I guess, is perhaps a little bit more recent, Michael Burt was a rock star back in the day. Okay, back in the day. This guy's been a lawyer for almost as long as I have been alive on this planet. He represented Richard Ramirez, the Night Stalker, back in the San Francisco trial. Now, you may not remember the San Francisco trial because it's not the one that got him convicted and sent to prison. He was never actually convicted in San Francisco because he was found to be incompetent, unable to participate in his defense. And so the case was stayed and then ultimately was never brought forward to trial. So rather a beneficial outcome for his client in that particular case. Ramirez was also not a particularly easy client, a particularly manageable client. There's just some stories about the case that are like, give me some flashbacks, to some of the more difficult people that I would have to deal with. I'll just give you an example. They kept needing to get him psychologically examined, and he would have difficulty getting through the psych exam because the psychologist was a female and he could not masturbate when she was in the room. They're just not things that are helpful in terms of being able to build a defense and get your expert on side and stuff like that. So used to dealing with some pretty difficult people. So Richard Ramirez is in his background. That was back when he was at the San Francisco Public Defender's Office. He represented. Now I'm going to space the name of the guy, but it was the guy Eric Randolph, the Olympic bomber the one who like actually did it, not the guy who didn't do it that they framed up to do it. Represented him. And then most famously, what we're going to be watching in just a minute here, Lyle Menendez. He was on Lyle Menendez's defense team for his first trial, the trial that resulted in a hung jury, the one where the jury was split on essentially whether they bought into what was kind of a self-defense argument, or thought they were bad kids, bad intent. Trying to get their parents' money and control over the estate and so forth, and committed the murder intentionally. So a hung jury by most definitely public defense standards, but even really just defense in general standard is generally a win. If the state wasn't able to prosecute, wasn't able to convict your client, you did pretty well. You came out on the upside of that one. So just a couple high profile instances of extremely successful results by Mr. Burt. So I do have some stuff to share with you first. His just starting from the very beginning when he was brought into the case, they have to file a motion to admit him pro hac vice because he is from California. He's not licensed in Utah, so he has to get special permission to practice there. And what stands out is this here, State Bar of California for Certificate of Good Standing. You can't see the whole text, but his admit date here, oh, there it is. Just had to scroll. His admit date, November 29th of 1978. Okay, nearly 50 years. Nearly 50 years. This guy has been doing this. Okay, he has been around the block. Here is his declaration that he has to file. He's been in the practice of law for 47 years. Emphasis exclusively on criminal defense work for the entirety of my career. Almost 50 years defending criminal cases. Tried over 50 cases to a jury, 8 lengthy capital cases in state or federal court that he's tried. He's been appointed learned counsel in the federal appellate system in 27 federal death penalty cases throughout the country. He's previously appeared as lead or co-counsel on 8 capital cases that proceeded to verdict, many others that were resolved prior to or during trial. He has not only attended the required CLEs, he's the guy that presents at the CLEs in excess of 120 hours that he himself has been the teacher to the other capital attorneys on. He is on the AOC for the U.S. courts as a federal death penalty resource counsel. So he is appointed all over the country to assist in federal capital cases to make sure that they know what they're doing and they know what the standards of effective representation are and so forth. And so therefore considers himself to be qualified at the trial level. Yes, I would fucking say so. Okay. So humble. This guy is one of the most qualified people in the entire country. Okay, it's just the bottom line. He teaches the small little universe of capital defense lawyers how to be capital defense lawyers. So yeah, this guy, top notch. Really not a whole lot of question about that. So yeah, most of his career, at least like the first, I think 20 some years in his career, he spent with the San Francisco Public Defender's Office. I looked through some of his cases that I was able to find, some of the less high profile ones. And I still have more that I want to look through. But I am finding kind of a lot, the same sort of pattern that I found with Mr. Novak, which is just basically, this is somebody who is extremely persistent. They clear the field of issues that they see, even if they aren't like necessarily good right now. They're looking forward to the future. They're looking at big picture things. There's a case where he was litigating the fair cross section of the population in the jury pool, and whether you achieve that with the selection means that many states, and in this particular was in California, state uses, like many others, they pull the prospective jurors from the voter registration and from the Department of Licensing records. And so it's been like well established for many, 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 many years, like long enough that I myself have litigated this particular issue. Well established that this does not it selects for certain demographic characteristics and tends to exclude others. So you don't really get a fair cross section of what the community actually looks like. Just some other kind of generic issues, but I wanted to share this particular one because I just have this gives me insight into him. Okay, the date of this, October 9th, 2009. 2009. And what is this about? This is a Daubert hearing on toolmark comparison. Okay, the bullshit that we've been talking about from Richard Allen, you know, and beyond, the scientific problems that just underlie this particular methodology, the way that it goes, it just overstates is really the problem. It's a problem with a lot of these disciplines. They overstate the conclusion that you're able to draw as a matter of, like, you know, scientific validity from the type of comparison that they're doing. And so because of that, we've got now Maryland and Oregon courts have said, you're not allowed to do this. You can't testify that a gun matches a particular piece of evidence, a bullet or a shell casing or something like that, because that's overclaiming. That's beyond what science allows you to be able to do. You cannot exclude any other firearm in the universe from being the one to fire this rifle. And so fire this cartridge or this evidence. And so these criticisms have been coming about since, well, right about this time frame, because what happened is the National Academy of the Sciences did a big review of toolmark analysis among all kinds of other forensic disciplines and found that it's got a problem. It's got a problem. It doesn't meet general standards for admissibility. And so that's what this opinion is. They go through and they explain, here's what the conclusions are, here's what the testing does, here how they do it. Like, guys, it's literally an eye test, literally an eye test. They look at it through a microscope and say, does this look close enough? You think I'm exaggerating, but I'm not. That's really what it is. Also, you Richard Allen folks, check this out. Check this out. He testified about the micro photographs he took of the observations of the recovered bullet and various test fires in the comparison microscope and used copies of those photographs to explain how he reached his conclusion. That's so funny, because I remember in the Richard Allen trial, remember, you guys weren't there in the courtroom, so you didn't get to see, unless it got, you know, released as part of the evidence that came out, the side-by-side photos that she presented of her comparison, and you're like, what the fuck is this? And she testified, her explanation is that the photographs aren't there to document anything. You know, we aren't supposed to be able to look at these photographs and see and, like, you know, agree with her conclusion or not. They just take them as a memory aid, because you don't see on the photograph a two-dimensional thing, what you see in the comparison microscope, which is also a two-dimensional thing, but I don't know, whatever. Anyways, y'all remember that testimony that she takes the photographs just because, and we shouldn't be allowed to look at them with our own eyeballs and reach conclusions about whether we with our eyes think these things look close enough to each other to match or not. Only her with her magic eyes and her micro photographs were able to do that. So anyway, yeah, the recent National Academies report, okay, back in 2009. So not only this is early litigation on this particular issue following the National Academy of the Sciences report back when it was still fresh. So he was one of the early adopters to this. I feel for him because here it is, not quite 20 years later, but getting awfully close. And we're still dealing with this same bullshit. Still dealing with it. Don't be surprised if we see this same motion come up in Tyler Robinson's case, because still hasn't been resolved. They haven't fixed the methodology. They've just continued to persist with, saying, yes, we can match it and so forth. So we shall see what comes of all that. So that is just a little bit of background to get us to what I am very excited about, which is this closing argument. So I haven't watched it yet, guys. We're going to be watching this together for the first time. It is a little bit long. Now, having said that, it's about 2 hours long. But having said that, by today's standards, 2 hours seems fairly normal for a closing argument. But what's, for me, like straight off the bat already real impressive about this is that the trial was 85 days that they were taking evidence. This case was in trial from July to December, just in the taking evidence phase. And so to be able to like sum up your case and your defense in 2 hours, given how long the case had gone on, to me, that is already pretty impressive. So with that, guys, let's take a look. Let's see how this guy rolled back when he was in his prime. This was like peak of his career. He was about 25 years in the San Francisco Public Defender's Office at that point in time. He was brought on by the defense team for this trial. So had already kind of earned himself a reputation as a top lawyer, somebody that you wanted to have on the team. And his results do kind of speak for themselves. But let's see how we did it, because this is likely what we're going to see from him when it comes to Tyler Robinson's case.
Presented, jury's back in the jury box. Now we'll have the beginning of the defense argument. Mr. Burt.
Thank you, Your Honor. Ladies and gentlemen of the jury, when it boils down to it, when all the lawyers in this case finally stop talking, I think you're going to see that the real issue in this case is what was going on inside the minds of two young men on August 20th, 1989, when they opened fire with two incredibly loud shotguns in the middle of a residential area about a mile away from the police station, and then ended the lives of their parents. Was this an act, as the prosecutor says, of two cold-blooded killers who were bent on committing the perfect crime, and thereby to satisfy their lust for greed or their desire to gain back control that they had lost to their parents, or now, as the prosecutor claims, over some dispute concerning a camera recorder? Or was this instead a response of fear and panic that followed year after year after year of abuse by two bullying parents, an abuse which resulted in that final week that you heard excruciating detail about here, which culminated in Lyle Menendez telling his father that he wasn't going to abuse his younger brother anymore. That's
okay. Let's pause this for just a minute. So we have I don't know why that went small. Let me get that back big again. We have right off the bat a couple of things that I think are really, really noteworthy. So number one, right off the bat, no argument that they did it. Okay. They're not going to, I don't know, try to spin the evidence or anything like that in some way to try to argue, factually they didn't pull the trigger. He's conceding on the weak issue. It's a smart thing for a lawyer to do. It's a very smart thing for a lawyer to do. You have to be able to have the perspective to look at your case and think, how are reasonable people, objective people, haven't heard anything about this, don't know us from Adam, no investment in the outcome. Those people looking at this evidence, what are they going to think about it? And you got to be able to put yourself in their shoes and develop your trial strategy accordingly. And so if they're going to look at you like a crazy person, okay, like you're babbling in tongues on the street corner, if you're trying to tell them your client didn't pull the trigger, they're going to be like, whatever, dude, then they're going to turn you out and you've lost your credibility and they're not going to listen to anything you have to say. So there's a tendency a lot of times that some lawyers will have to just like try everything, well, he didn't do it, but if he did do it, then, this and the other and so forth, like to just try to get every single little thing. But that can cost you. It can cost you your credibility to do that. So knowing when to concede and what to fight over, really, really important talent when it comes to your ability to actually be persuasive. So conceding right off the bat, very, very noteworthy. Setting it up as a decision, right? Something for the jury to decide, is it this or is it this? It can be risky to set things up as a binary. Lots of times as the defense, you don't want the jury thinking either or. You want the jury thinking, any possible explanation other than the state's. But, if you think you got a pretty strong position on your binary, or you got at least a few people that will buy into it, then the either or can be a strong way to go. You have to kind of buy everything the state says, or you got enough doubt. Maybe it's this other situation. Then you can't convict on the state's theory. So noticing the choice right off the bat, and then the last thing there that really stands out to me is just he's got it extremely well simplified. It's about, was this a cold-blooded murder, or was this a response to years of abuse? It's very, very simple to understand that distinction and that choice. And so to be able to kind of simplify it and lay it out just like that. And now I'm going to spend a lot of time backing up why we should accept the one version over the other. May not seem like the most important skill, but after 85 days in trial of hearing evidence, it's so easy to get lost. It's so easy to get lost in the case and all of the details, and the this and the that and the that conflict and the this other thing and the this thing that pissed me off and all that stuff. And so the ability to continue to stay at that 10,000 foot level of just, this is like the big picture of what it's all about. And then we'll drill down into the details, and some of it will matter, some of it won't. But here's what he thinks matters and why it supports his outcome. You don't get that without an awful lot of experience along the way.
That's really the issue in this case. And the answer to that question is, or may be, a life or death one for Lyle Menendez. And because of the importance of that question, we spent a considerable amount of time since July, when you were selected as a jury, really exploring all aspects of the case. And it was done because Lyle Menendez's life may be at stake in these proceedings. We do operate in a civilized atmosphere here, but it's important, I think, to realize that what's at stake here may be a life or death decision. And that's why we explored at times what to you must have seemed like mind-numbing detail. It was really just an attempt by both sides to do their best job in a case that has very, very, very important consequences for the people who sit at that side of the table. And it's important now that you as jurors, each and every one of you, understand not only the facts of the case, which you've heard since July of this year, but also the law. And I'm going to be talking primarily to you about the law this afternoon.
So that's a good little preview because, you know, if you got the facts on your side, you focus on the facts. If you got the law on your side, you focus on the law. And this doesn't seem to be the case where there's great facts on their side. You know, certainly there's a lot of bad facts. Let's just put it that way. It's not that they didn't have any evidence on their side, but there were an awful lot of bad facts that they were going to need to deal with. Now, look at how confident he is. Okay, he's speaking off the cuff. He's not reading. Okay, he doesn't have this memorized. He's not stumbling over his words. He's very smooth. He's looking at all of them. There's no sense of like, I don't believe what I'm telling you. I'm ashamed of what I'm telling you. Like, maybe you disagree. I don't know. You guys tell me, but I get authenticity from this guy. I get sincerity from this guy. Whether or not I agree with him remains to be seen, but I'm not getting any sense that like he doesn't believe what he's saying. And that's really crucial. That is a crucial part of being persuasive to a jury, because they can smell bullshit coming from you. They can tell right away if you're just feeding them a line that you don't really buy. And so really, really important, if at all possible, to frame your defense around something that you actually do sincerely believe.
I will mention some facts. Specifically, I'm going to talk a little bit about the coroner's testimony, and I'm also going to talk about the credibility or lack of credibility of some of the people's witnesses. But primarily, I'm going to be talking about the law this afternoon in the time that I have remaining. And then tomorrow, Ms. Lansing is going to explore with you in detail both the defense witnesses as well as some of the prosecution witnesses, and we'll respond to some of the arguments that Ms. Bozanich made during her closing argument.
So it's a team approach. Once again, already kind of seeing he's on a team for Tyler Robinson. He was on a team for Lyle Menendez, 33 years ago now. Used to it, used to the division of labor and being able to coordinate and so forth. And they have even set it up where he's the law guy for the closing. And so he's the law guy. He's going to deliver the law. And then the other attorney is going to, you know, follow off of him, riff off of what he has to say, and use their evidence to further develop the themes of their defense.
But the law in this case is important. The details of the law are important here, however boring they may seem, and especially boring at 3 o'clock in the afternoon. The reason the law and the details of the law are important here is because, as you're going to learn shortly or tomorrow probably from the judge, you as jurors have two basic duties to perform here. And the judge is going to tell you that your first duty is to determine what the facts are. You are sitting as judges, and you are the exclusive judge of what the facts are. The judge cannot tell you what the facts are. Ms. Bozanich cannot tell you what the facts are. I can't tell you what the facts are. You decide what the facts are in this case, and no one can tell you otherwise if you decide the facts are a certain way. That's one duty you have to perform here, is to decide what the facts are. And you've heard conflicting testimony. It's going to be your job as judges to decide what those facts are. And you're also going to hear from the judge that the second duty you have to perform here is to apply the law as the judge gives that law to you, even if you disagree with it. And the law that the judge is going to give to you will be contained in the instructions, which he's going to read to you. Hopefully you'll have a copy of those instructions to take into the jury room with you. Some of those instructions were discussed by Ms. Bozanich. I probably will be repeating some of the instructions she talked about. I don't think it hurts to hear it twice, because these are difficult concepts, even for lawyers. If you understand them already, fine. If you don't, I hope some of the things I'm going to say about the law will be helpful to you. And I'm going to discuss in detail the law. And then, as I say, Ms. Lansing will discuss with you tomorrow how to apply that law to the facts of this case. And as the judge is going to tell you tomorrow, the reason you have to apply the law to the facts of the case is that the ultimate goal here is to arrive at a just verdict. Both sides have a different version of what a just verdict means in this case. The prosecutor thinks a just verdict is for you to convict Lyle Menendez of first-degree murder with special circumstances. And it's her hope that ultimately that decision will lead to another decision which could send Lyle Menendez to the gas chamber. The defense, on the other hand, of course, has a different version of what justice will be in this case. And it's going to be up to you to decide ultimately where justice lies. But it's not a free-flowing decision. You don't just go back and say, well, I think this, or I think this is the way the law should be. It's justice reached within the court's instructions. And that's what guides us through your deliberations, is the law that the court is going to give to you. So what is it legally that you're going to be asked to decide here? And how do you go about doing it? Ms. Bozanich talked to you a little bit about the various options that you're going to have here. And I want to discuss those options with you as she did, but in a little more detail, in hopes that it will clarify for you what decisions you're being asked to make here, because it's not just a decision of is Lyle Menendez guilty or not guilty of murder in the first degree. There are other decisions you're going to have to make. And so I want to make sure that everybody understands the various paths that you can take under the court's instructions.
So I find off that he's a little difficult to pause on because he does continue his thought process a little bit. I think he's going to conclude and then he doesn't. He continues and ties it into something else. But that's okay. Always nice for the jury to get a little help with what their job is. The jury is not the legal experts. They're the ones who are the novices most of the time to this whole thing, and they have a very important job, and it can be a little bit stressful wanting to make sure you do it right. And so focusing this on the jury and what they're going to need to decide, break it down, make it nice and simple, and doing this early in the process, this is being helpful. This is really being able to anticipate the kinds of things that the jury is going to be concerned about, and acknowledging them and their part in the process and what their part in the process is. I see all of this as very respectful and just likely to get a jury to like you more. When you make their job easy, they appreciate that. And he's doing it in this very, very calming. He's not overwrought. He's not excited, anything like that. He's just a very straightforward kind of helpful explanation. I don't know. I can see how this approach, the jurors are going to like it.
And we prepared for you a little flow chart here.
And a visual?
Hopefully will be helpful in explaining what the various options here that we're dealing with. And as Ms. Bozanich told you, we start up here with the charge of 187 PC is 187 of the Penal Code. And that's the Penal Code section which defines the crime of murder. And Lyle Menendez in this case is charged with murder with special circumstances. And special circumstances, as you learn at the very beginning of the case, are the thing which distinguishes first-degree murder from a special kind of murder, which ultimately could lead us down here, which is in a second trial where you'd be asked to decide the question of penalty. And at that stage of the proceedings, your only options would be death on the one hand or life imprisonment without possibility of parole on the other. That is the importance, the significance of the special circumstance allegations in this case. And Ms. Bizanich talked about checking off the multiple murder special circumstances if that was an unimportant decision. It's a very important decision because of where it can lead you in the decision flow here. So I'm asking you to keep in mind that the charges here are not just murder, but murder with special circumstances. And in this case, there are two. The two special circumstances are multiple murder and murder while lying in wait. And I'll get back to what those two terms mean in the law. But for now, we start up here with those charges. Those are the charges that you're faced with when you go back into the jury room. So you have the charges, and the first decision you're going to be asked to make, or one way in which you can decide to go about your deliberations in this case, would be to decide, well, is Lyle Menendez guilty or not guilty of murder? Just the question of murder. And I'm going to talk to you in a minute about what murder means. But the first decision you would make is guilty or not guilty of murder. If you were to decide that he is guilty of murder, then the question would become, what kind of murder is he guilty of? Your options would be two. He could be guilty of first-degree murder or second-degree murder. If you decided that he was guilty of second-degree murder, your decision would end here, and you would then go back to the second charge of murder, because each charge here, you have to follow the same course. So if you went through as to one charge, for instance, the charge of murder against Jose Menendez, and you decided, well, he's guilty of murder, but we think it's murder in the second degree, your decision as to that charge, that is murder against Jose Menendez, would end right here. You wouldn't go any further, and there'd be no need to reach the decision down here on the question of penalty. But you'd still have a second murder charge, and you'd go back and decide that in the same way. That is it murder? Is he guilty or not guilty of murder? If he was guilty of murder, is it first or second? If it was second, you'd end there, and that would be the end of the trial. You'd still have to decide conspiracy charges, which I'll discuss later. But as far as the murder charges would be concerned, you would end your decision-making there.
So how helpful would a chart like this have been in the Karen Reed case, where you have all of the different lesser includeds and so forth to have to be able to work through? I like the chart. I think the chart is a way of being able to talk the jury through what to the lawyer it's a very simple visualization. But to the jury, it's not. They're new to this. They haven't been to law school. They don't know, the framework between murder and manslaughter and the degrees and the special circumstances and all that type of stuff. So you can tell them, you can explain it, and that's definitely helpful, the way that he's doing it. But the visual has the potential to stick in a way that the words don't. So just giving them this map alone is giving them something that, they close their eyeballs and can kind of still see, oh yeah, the forks in the road on the backs of their eyelids. That's a very valuable and powerful thing to take into the jury room. And I think it just, visuals are really helpful. Really, really helpful. They're helpful in trial. They're helpful in the briefs. Appellate work, like sometimes to make a point, you really do need to embed one of the pieces of evidence, like a photo, into the brief, or, you need to have something visual that you can see. Just makes the point so much more powerfully than just following the words does. So the fact that he made this whole chart over, something that may not be, it's obviously not like case evidence or like that, but this is the jury's job. This is the most important thing for them to do, arguably. So make it easy for them to follow you and to remember that and to take it to the jury room. Put it on paper. Really like that decision.
No need for further decision. If, on the other hand, you decided as to the murder charge on Jose Menendez, not guilty, that you didn't think murder was committed here in any degree, then you would find not guilty, but you would still have a second decision to make. And the second decision would be, okay, he's not guilty of murder. Is he nevertheless guilty of what the court will tell you is a lesser included offense, that is manslaughter? So you'd have to decide, is he guilty or not guilty of manslaughter?
Okay, so I didn't realize they had all of these lesser included options in the Menendez trial. And I have to say, it makes it even more impressive to me that they got a hung jury out of all this, because there were so many compromise options along the way. It means they had jurors who were like, no, not going to convict. At least one, you'd have to think. At least one who was like, not going to convict on any of it. I mean, I suppose it's possible that some people were like, I'd only convict on manslaughter, and some people who were like, I'd only convict on murder, and they wouldn't compromise, and so they hung. But either way, just when you have these many forks in the road, it's just, chances are pretty good the jury is going to find one of them that they can all live with. So the fact that they didn't in this case, I think, really says a lot to the quality of the defense that they put on.
And if you decided not guilty manslaughter, you'll be provided a verdict form for that. And by the same token, if you decided he was guilty of manslaughter, your decision making would end here. And you would then go back to determine the second count in the same way, and you could end up in the same box with the second count of murder. It's only if you decide that, number one, he is guilty of murder, and number two, it is murder in the first degree, do you get to this decision, which is the special circumstance charged in this case true or not true? Now, if you decided that Lyle Menendez was guilty, and he was guilty of murder in the first degree, you'd have to decide whether the special circumstances were true in this case. If you found that they were not true, the case would end there as to that charge. You'd go back up and use the same decision-making for the second count. And again, if you found it not true, you'd end up here and the case would end. And if, but only if, you found that charge true, in other words, you would have found that he's guilty of murder, that murder is in the first degree, and the special circumstance is true, would we have a second trial? And it would be at that stage you'd hear some additional evidence, and your options would be limited at that point to life imprisonment or death. And I think it's important to understand that. It's something that we discussed months ago when you were first brought in as jurors, and you may have been wondering how this all plays out in terms of will we have a second trial or not have a second trial. This is the only way you could have a second trial, is if you made all these decisions as to both counts.
This seems effective to me, a little suggestive. You guys want to be here for the second trial? You've been here for 85 days already. Okay, they've been there in court for like 5 months. Want to come back for some more? But also the way when he's showing the options, he's defaulting, defaulting to, you find, if you find not true, if you find, but then if you find, then you have to go all, he's like making it seem like kind of a burden, kind of a big deal to get all the way to the point of deciding death or not. It's a subtle thing, but just in the way he's presented it, I at least get the sense that, he wants to kind of discourage me from going down that road. It would be hard to do that. And it's going to mean we're going to have a second trial, which of course I'm not supposed to consider, but being a juror, You're going to be thinking about how much longer are we going to be dealing with this. So it's just a small little subtle thing to kind of play into, like, look how easy it is to take one of these other paths, and then the case comes to an end.
Now, as you go through the flow chart making these decisions, is he guilty or not guilty of murder? And if you found him, Lyle Menendez, not guilty of murder, is he guilty or not guilty of manslaughter? There is an overriding principle that we operate under in our system, and you're going to see it expressed in various ways throughout the instructions. And one of the ways you'll see it expressed is with this instruction, which says, two instructions actually on one page here. It says, if you are convinced beyond a reasonable doubt that the crime of murder has been committed by a defendant, but you have a reasonable doubt whether such murder was of the first or the second degree, you must give the defendant the benefit of that doubt and return a verdict fixing the murder as of the second degree. So that applies to this decision. When you're deciding guilty or not guilty of murder, if you decide he is guilty of murder and you say to yourself, I have a doubt as to whether it's the first or second degree, it's your responsibility under the court's instructions to give the benefit of the doubt to Lyle Menendez and find that it's murder in the second degree, and the case would stop us to that count right here. And by the same token, if you found unanimously he is not guilty of murder, and then you went on to decide the question of guilty or not guilty of manslaughter, the court will tell you, if you're satisfied beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder or manslaughter, you must give the defendant the benefit of such doubt and find it to be manslaughter rather than murder. So if you get to this point in your deliberations where you've said, we don't think it's been proven beyond a reasonable doubt that he's guilty of murder, can't really tell if it's murder or manslaughter, it's your obligation under the court's instructions to give him the benefit of the doubt and find that it's murder and find that it's manslaughter as opposed to murder. Now, reasonable doubt is a principle that's also going to be defined for you by the instructions. And it's probably, from our standpoint, from the defense's standpoint, the most important instruction that you're going to be receiving from the court, because it defines for you what the standard is for your decision. It's not a question, as you might have suspected from Ms. Bazanich's closing argument, of, well, which side do you favor the most? Who's telling the truth here? Choose between the two. No, you'll see from this instruction,
we're reliving the suffering of the pre-Elmo days, the pre-laptop days, a 1993 trial where you still had to do this stuff on the blow-up poster board. The struggle. We think it's bad now when, like, people can't figure out the tech and the stream doesn't work, and try turning it off and turning it back on. But, like, you know, there's always something, guys.
It's actually three concepts contained in this instruction. A defendant, and the three ideas in here are the presumption of innocence, proof beyond a reasonable doubt, and the definition of what reasonable doubt is. A defendant in a criminal action is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving his guilt beyond a reasonable doubt. And then the second part of this instruction tells you what reasonable doubt is. And it tells you that reasonable doubt is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charges or the truth of the charge. And there are a couple things about that definition I'd like to point out to you. One is you'll see here that it's after the entire comparison and consideration of all the evidence. And when Ms. Bazanich stands in front of you and says, you really only need to look at this bloody photograph to decide the case, that's contrary to the instructions. Because this instruction indicates to you that you're to decide this case not based on one bloody photograph or not based on the testimony of one witness, but the consideration of all of the evidence. And it's
what a classy correction. Okay, this is how to keep the high ground while also being like, that's some bullshit she just told you. Nothing personal at all, no attack, just you'll notice that's contrary to your instructions to just look at one piece of evidence. No, you got to look at all of it. Another way to be likable to a jury is don't make it personal. Don't try to make it a popularity contest. Just do your thing, make your case, keep your high ground, and don't worry about what the other side is doing. If you've done the work, okay, you know what your defense is, you know how you're presenting it, you know how you're getting it out at trial, you know how you're cross-examining the witnesses, and you carry out your plan, then that is really independent of, stuff the other side does. And so you don't have to get into a, big knockdown punching match with the other side. You can just say, even though inside you're like, what a bunch of, I can't believe she just said that to the jury. That's so unethical. What a bunch of crap. You can just tell the jury, when she said that, that's contrary to your instructions. I like it.
Only after considering all the evidence that you can decide whether the charges have been proven beyond a reasonable doubt and to a moral certainty, which is defined in this instruction. And I think the essence of this instruction is you have to feel, each and every one of you, because the court's going to tell you that each side in the case is entitled to the individual opinion of each of you. And what that means is no one can be convicted in this courtroom unless all 12 of you agree that the case has been proven beyond a reasonable doubt. And under our system, it's not the majority rules. We're entitled to your individual judgment. And if you feel, based on a consideration of all the evidence, that a charge has not been proven beyond a reasonable doubt, it's your responsibility under the instructions to hold to that view, if that's your view after considering all the evidence, and not cave in to someone else because a majority of people may disagree with you. The court's going to tell you that each side has and is entitled to the individual opinion of each of you. And each of you have to be able to say that you have, when you come out of this jury room and reach a verdict, that each of you have an abiding conviction to a moral certainty of the truth of the charge. To me, the word abiding means lasting. Long-term lasting belief or conviction. It's not a suspicion. It's an abiding conviction is something which months from now, you're going to be able to wake up in the middle of the night and think of this case and say to yourself, I did the right thing there because I had an abiding conviction in my decision. I believe beyond a reasonable doubt in the truth of those charges. It's something that I know is going to stick with me. And if you don't get to that state of mind, then under the court's instructions, you aren't entitled to find Lyle Menendez guilty of any charge. A way of thinking about reasonable doubt is in terms of various states of mind you might reach after listening to the evidence in the case.
Oh, we're gonna okay, so much focus on the reasonable doubt, right? Completely understandable. It's defense. It's like the main tool that we have in a trial, particularly a trial with lots of bad facts, is the reasonable doubt. And he's clearly done this, a few times. He's got his way of explaining that to the jury. I like the explanation because it's very visual. You can put yourself there. You can put yourself in bed 6 months down the road, waking up and thinking about what that would be like. Waking up like, ooh, I have this anxiety in the pit of my stomach because I'm just not sure I did the right thing. And how bad would that feel? And that's why you can't just rush to a verdict. You can't let the other jurors pressure you into giving up your own sincere belief about the evidence in the case, because you're the one that has to live with yourself 6 months down the road, waking up, and you want to be sure you did the right thing. It's kind of like a kindness that if you don't have to make a decision that you're going to worry about later on. You can be absolutely certain that you did the right thing as long as you follow the judge's instructions to stick with your own assessment. Don't give in to pressure. Don't change your vote just because other people don't like how you're going to vote and so forth. I like how he did that. I mean, I've seen a lot of different arguments for reasonable doubt. A lot of different lawyers, going through this similar kind of process. I like how he is doing this with the visuals. I like how he is doing it with the, just kind of being able to put yourself in the position of I've made the decision and how do I feel about it, and really personalizing it a little bit. That it is your decision and your decision matters, and that's why you should stick with your decision. And clearly there were some of these jurors that took that to heart. Everybody stuck with their decision and wouldn't change, and so therefore the jury hung.
And you'll see along the left side of this chart, I have listed various conclusions that you might come to after listening to the evidence in this case. You might be saying to yourself, well, it might be that Lyle Menendez had the state of mind which is necessary for first-degree murder. And as I said in the first sentence of my argument, the question here is, did he have the state of mind that's required here? Not whether he...
Such a good reminder. What is the scope of the reasonable doubt about? Like, while we're walking through this exercise, redefining for them what's the actual one that matters, okay? Because the pulling the trigger part's probably not going to be the issue here. You can believe that beyond a reasonable doubt that he pulled the trigger, but still be not beyond a reasonable doubt on guilty of the crime, because the crime requires more than that. And so you have to be focused on the state of mind, because that's the defense's really primary concern here. I like the redirection on that.
Killed his parents, because there's no dispute about that. The question here is his state of mind, as I'll explain to you later. You might listen to all the evidence in the case, hear the arguments of the lawyers, and say, I think Lyle Menendez might be maybe guilty. And as you move up this line, this side of the chart, you'll see your suspicions growing. From he might be guilty, he possibly could be guilty, I have a suspicion he's guilty. It's likely he's guilty, probably he's guilty, all the way up to here. A strong suspicion that he had the state of mind that's required for murder or manslaughter or whatever. All of those states of mind under the court's instructions lead you to not guilty verdicts. And it's only if you get beyond this stage, beyond a reasonable doubt, abiding conviction, moral certainty, that you can say anyone is guilty of any criminal charge, whether it leads to the death penalty or not. That's the way our system works.
It is, yes.
How
and the defendant goes over the top and tumbles.
Are those concepts in our system? You probably don't recall this, but back in July, you were required to fill out this lengthy jury questionnaire. It was hundreds of questions, and we apologize for that. But it was necessary so that we got to know you in a very short period of time, and it was the only way under the law that we had of doing that. And in those jury questions, which both sides were provided and they used as a basis of evaluating whether you should serve in this case or not, there were two questions asked everyone on this jury panel. The first question we asked you, or one of the questions we asked you, was whether you agreed or disagreed that regardless of what the law says, a defendant in a criminal case should be required to prove his or her innocence. And everybody who's sitting on this jury said that they strongly disagreed with that statement. They strongly disagreed that the defendant should be required to prove his innocence.
Good jury.
And the second question we asked you was whether the criminal justice system makes it too hard for prosecutors to convict people accused of crime. And we asked you to comment on that. And I think that your comments as a group probably speak more eloquently than any lawyer could ever speak on how highly we value the concepts of presumption of innocence and proof beyond a reasonable doubt. These are some of the things you said. The Constitution is for all Americans, innocent until proven guilty. The system is set up to protect the innocent and convict the guilty, who sometimes enter the system together. The process must be hard enough to separate the guilty from the innocent, yet fair enough to be just to all it serves. Another person wrote, I believe that it should be hard to convict people accused of crimes to protect the innocent. Someone else wrote, sometimes in the past it has seemed too hard for police and prosecutors to convict, but that is perhaps why our country is the best in the world. I cannot agree to disregard what the law says. We go by innocent until proven guilty. I feel it is the best system I have heard of. I agree that a person is innocent until proven guilty. Defendant is in a tough position already. And if the defendant has to prove his or her innocence, then there is already a negative tag of guilty on the defendant.
Okay, I love this so much. I love this so much. Like, not just because these are great things that they've said, and so we've picked a good jury here. We did a good selection process. We asked good questions in the questionnaire. We got these detailed, kind of open-ended sorts of answers from the jury that's going to probably tell you a little bit more about how they really think than just yes you think this, no you don't think that kind of situation. But I'll tell you what I like about it so much. If these are words that these jurors said, they are hearing their own words coming from this lawyer. Okay. They're going to recognize, oh, he's saying this thing. I said that. And isn't that going to just like automatically, even in a very small way, a very subtle way, give you a little bit of affinity for this lawyer? Like, I'm on his side. He's reading my words to me. Like he's praising my words. So I kind of like him a little bit. I really like this. I think this is very smart. I think people are going to like to hear themselves being mirrored back from the jury. A lot, if not most of his arguments so far, I feel like really has been focused on the jury and their perspective and what they're going to be asked to do and helping get them through it and so forth. This is not a lawyer talking from the lawyer's perspective. This is the lawyer interpreting. He's trying to put himself in the juror's shoes and interpreting the legal process and the standards and everything in a way that they can understand. And so then hearing him mirror their own words back to them with this kind of attaboy, like, yeah, you got it. You get it. You got this, guys. Like, I feel like this guy is on my team now. This is like brilliant. I had never thought about reading parts of the jury questionnaire answers back to the jurors, but I freaking love it. I love it.
I think our system works fairly well, and it's the best system there is. It is our basic right, and to innocence until proven guilty. Defendant is innocent until proven guilty. It is not easy and should not be easy. And lastly, I think the accuser should prove the accusation. And that's a very good, succinct way of saying the way our system operates. The accuser, in this case the prosecution, should prove the accusation. And this is how strongly this particular group feels about the principles of law I've been discussing with you. And we really took your word for it when you wrote those words down, and we trusted that you were going to abide by what you wrote there in terms of saying that you're going to hold the prosecutor to that burden of proof beyond a reasonable doubt and to a moral certainty. So there's no question in this case that the burden of proof is on the prosecution to prove beyond a reasonable doubt the truth of the charges in this case. And what is it exactly that they must prove? Ms. Pizanich went over it in a little bit of detail, and I want to give you again an overview of what I think it is that's at issue in this case.
So many visuals.
We start, as we did up on the flow chart, with the charge of murder. And I'm going to be discussing primarily the charge of murder here because, as you'll see under the court's instructions, the conspiracy charge will depend on whether you find, first of all, that there's an agreement. There has to be proof of an agreement. And I have yet to hear from the prosecutor when that agreement was formed or what the agreement entailed. But there must be an agreement, and it must be an agreement to commit murder. Two elements of conspiracy. And the court will instruct you that in order to find an agreement, a conspiracy to commit murder, you must find that Lyle Menendez had the same intent that he would have to have for the charge of murder. So really the charge of, and the same with conspiracy to commit manslaughter, you're going to learn that under the court's instructions, that the charge of conspiracy and the charge of murder really involve the same issues. And it's the case in this particular instance that by resolving the charges of murder, you will also see the way to go on the charges of conspiracy. So it's really the murder charges that I'm going to focus on here, and I'll explain to you a little bit more on the conspiracy charges later. But the basic charge of murder in this case is, and the definition of murder was given to you by Ms. Pizanich. There are three elements which she must prove. And under the court's instructions, as we go through these crimes, there are certain elements or parts to each crime I'm going to be discussing. The prosecution is required to prove all the elements. She can't get by with proving 2 out of 3. She can't say, well, I showed you that a human being was killed, and I showed you that the killing was unlawful, and there's a little bit of doubt on the malice aforethought part of it, but 2 out of 3 is not bad, so I win. No, it doesn't work that way. She only wins if she can prove beyond a reasonable doubt and to a moral certainty that each element of whatever charge is being discussed, be it murder or manslaughter, is proved beyond a reasonable doubt. So the 3 elements of murder are at the top of this chart. And there's actually a fourth, which is the defendant was the person who committed the murder. That is not a contested issue in this case. As I indicated to you, it is a contested issue as to whether it's murder, but it is not a contested issue that Lyle Menendez was the person who killed his parents. That's a homicide.
This is like the 3rd time now. He said, guys, no dispute. We're not challenging this. He killed him. So it's like reiterating that point. It seems like clearly this is a bad fact. Normally, you don't try to highlight your bad facts. But helping kind of narrow the focus. Like you don't have to worry. You don't have to worry about, like, we're not disputing that. We're helping you here. We're going to try to save your time and save your effort. You don't have to worry about this one, okay? He killed him. He killed him. That's not the issue. The issue is what was going on in his mind when he did it. That's what you have to decide. I don't know how you come out of that and think, well, that's not reasonable. You know, God, it's so reasonable and very helpful. And it does buy him credibility with me.
The question is whether it's a murder or something else. So the three elements that are here that I'm going to focus on are a human being was killed. Of course, that's not being contested. The killing was unlawful, and it was done with malice aforethought. And the third element is the element that is really at the heart of the contest between the prosecution and defense in this case. And the court is going to define for you what malice is. And the court will tell you that malice is express. And this is a funny definition because the court will not tell you what it is. The court does not say, here's what malice is. This is the way the instruction reads. It says malice is expressed when there is manifested an intention unlawfully to kill a human being. There's also going to be a second.
That's terrible. What an awful definition. What an awful definition. And thank you for pointing out, this isn't my fault, guys. This is just the terrible wording. Oh my Lord. Have they updated that? Has California updated that? I doubt it, but that is bad. That is not a good one. Manifested an intention unlawfully to kill a human being. This is like you too concerned about like this splitting the infinitive and so forth. This is terrible. It doesn't flow. But he's going to make sense out of it for us, I bet.
Kind of malice that the court's going to tell you about, and that's something called implied malice. It's not listed on this chart, but another way that you can find malice is implied malice. And implied malice usually applies to a situation where someone does not have an express intent, has not manifested an express intent to kill someone, but he does some act that is so highly dangerous that it's the same under the law as having an intent to unlawfully kill somebody. An example that's usually given is someone comes into a crowd of people with a bomb or a hand grenade and says, gee, I don't know anybody in the audience out here, but I think I'm going to throw this lighted hand grenade into the audience. Well, that person may not intend to kill any one particular person, but the act of throwing a hand grenade into a crowded room is so dangerous that the law in those circumstances equates that act with an intentional killing. And that would be an example of implied malice. What I'm going to focus on in the instructions, because I think it simplifies it, is the concept of express malice. And express malice is manifested when there's an intent unlawfully to kill a human being. You'll see under the court's instructions that intent to kill is also an element of manslaughter. And the court's going to tell you about the difference between murder and manslaughter. And you'll see that voluntary manslaughter is an unlawful killing where there is an intent to kill, but no malice aforethought. And involuntary manslaughter is an unlawful killing where there's no intent to kill. And murder is an unlawful killing where there is express malice aforethought. And express malice aforethought occurs when you have an intent to kill and there's nothing else which reduces that intent to kill to manslaughter. Once you've found that malice is present, once you've said that there is, in this evidence, proof beyond a reasonable doubt that the defendant intended unlawfully to kill a human being, and it is not second degree, and it is not self-defense or unreasonable self-defense, I should say, and it's not sudden quarrel or heat of passion. If you find that there's express malice, then under the decision tree that we started with here, you would have to decide whether it's murder in the first degree. And murder in the first degree has various elements or parts, just like murder. To get it beyond murder and into the category of murder in the first degree, the prosecution must prove certain things. And as Ms. Bizanich said, the instruction on first degree murder is lengthy, fairly complicated, but it's important that you understand it, because her approach was to say, well, you all have some idea in your mind about what a first degree murder is, but our own ideas of what a first degree murder are or what they should be may differ with what the law says a first degree murder is. And you might say to yourself, well, what difference does it make? The victim of a manslaughter is just as dead as the victim of a first degree murder. And so why should the jury be concerned with these fine legal distinctions between first degree murder, second degree murder, manslaughter? I think the answer to that is that the law recognizes that, as the prosecutor said in her closing argument, people are just human. They have certain human frailties, and an intent to kill someone that's formed under extenuating circumstances, although it may be unlawful and therefore an act of manslaughter, is not in the same category as a willful, deliberate, premeditated murder. And by the same token, a willful, premeditated, deliberate murder is not in the same category as a second degree murder, which is a murder where you have an intent to kill, but no evidence that it's deliberate, premeditated, and so forth. So the law makes these distinctions in recognition of the fact that people are not equally culpable and that all unlawful killings are not the same. Some unlawful killings are more culpable, more blameworthy than others. And that's why these distinctions are important. That's why it's important that you understand what the distinctions are in this case, even though it gets somewhat technical. First degree murder is, and there's a typo up here, but all three of these elements must be proven to get first degree murder. Prosecution must prove, in order to get a conviction for first degree murder, that the murder was willful, deliberate, and premeditated with express malice aforethought. That's what first degree murder is. And the word willful, as used in the instructions, means intentional. The word deliberate means formed at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. And then the instruction goes on to tell you the circumstances under which first degree murder would be present. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was a result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not upon a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. And then it goes on to say, the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing at murder in the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he decides to and does kill.
Okay, we're kind of, for me anyway, very much now into the lull point of the argument. And the reading doesn't help. Reading doesn't help. And that was a very long one to read. He read it. But there's always going to be one. It's kind of like even in a case where it's all about the facts and you're just talking about the evidence and stuff like that. There's going to be parts of it that are more boring than others, and so people are just going to tune out. And so, to the extent possible, it's good to kind of tailor the boringness to the stuff that's less important. And so I'm not going to say that like this isn't important. Of course it's important. The distinctions very much do matter. But we are also now very much in the technical part that is going to be repeated when they're read the jury instructions. And so it's not necessarily critical that this stuff sits with them nearly as much as like those the not guilty mountaineer game, that visual and the visual of my flow chart and the knowing that it's no dispute over whether Lyle pulled the trigger. It's just about his mental state at the time. Those are the bottom lines that we have so far, and those are sticking. So I don't mind too much that we're kind of entering the lull state. Everybody can kind of check out and take a little nap, one of those naps with your eyes open for 20 minutes or whatever. I don't mind so much that that's happening at this point.
So, under the instructions, in order for it to be first-degree murder, you must find that it's deliberate, that is careful thought and weighing for and against the decision to kill. You must find that it's premeditated, that is, that the thought is considered beforehand. And you must find that it was committed with express malice aforethought, that is, that it was committed with an intent unlawfully to kill a human being. And in order for the murder to be of the first degree, you must find that the killing was by a clear, deliberate intent to kill formed upon a pre-existing reflection. No sudden heat of passion or other condition. If there is a sudden heat of passion or other conditions, such as we'll discuss down here, unreasonable self-defense, which precludes the idea that someone was carefully weighing the considerations for and against death, then it's not murder in the first degree. It would be, in those circumstances, murder in the second degree, unless it was something less than murder in the second degree under the instructions, which I'm going to talk about now. So in this case, if you were to say, after considering all of the evidence, if you were to choose that path in the chart that I began with, which says, I think that this case was murder, I think that murder was committed here because there was express malice, an intent unlawfully to kill a human being. But I don't think there was the careful thought and weighing for and against the killing, and I don't think it was premeditated. Then the most it would be is murder in the second degree, because that would be a murder where you have express malice aforethought, but the evidence in your mind is insufficient to establish premeditation and deliberation. If you got to that point, then you would have to decide the question of, if you got to the point where you thought it was neither, that is, you didn't think it was murder in the first degree because there was no deliberation and premeditation, and you said to yourself, I have to then consider the question of whether it is murder or manslaughter, then you would get to the next instruction, which tells you about the distinction between murder and manslaughter. And again, I realize this is incredibly tedious, but it's the only way we have of explaining to you in a crash course what the law is so that you can intelligently decide this case.
He's so insightful. He's like so self-aware. Like, guys, I know this sucks. It's boring. Stick with me. Very perceptive. Good skill to have. Appreciate the experience that the jury is having, and not to kind of separate yourself as, distant from or above or beyond them or anything like that. Nope, he gets it.
So the distinction between murder and manslaughter, as I mentioned a moment ago, murder requires malice, manslaughter does not. When the act causing the death, though unlawful, is done in the heat of passion, or is excited by a sudden quarrel such as amounts to adequate provocation, or in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intent to kill exists, the law is that malice, which is an essential element of murder, is absent. And it goes on to say, to establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder, and that the act which caused the death was not done in the heat of passion or upon a sudden quarrel, or in the honest, even though unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So you'll see under that instruction that when you're deciding what distinguishes or what reduces murder to manslaughter, you basically have two options. First of all, you have the option of self-defense. And under the law, if someone actually and reasonably believes that it's necessary to defend themselves because they honestly and reasonably believe that they're about to be killed or they're about to suffer great bodily injury, that person is not guilty of any crime. That would lead to an acquittal. In this case, you're going to be given instructions about a different kind of self-defense, and it's a self-defense which is called imperfect self-defense.
In other words, it's not self-defense. Doesn't qualify.
Imperfect self-defense is where you have an actual, the person really actually believes, but he unreasonably believes that it's necessary to defend himself. And in that situation, the crime is manslaughter. It's voluntary manslaughter if there is an intent to kill. It would be involuntary manslaughter if you were acting unreasonably and you didn't have an intent to kill. An example of that would be at various points in the testimony, Lyle Menendez was asked, what were you thinking when you put the gun against your mother's cheek? And he responded, on several occasions, I wasn't thinking. I was acting in a panic state. I was acting automatically. And Dr. Burgess attempted to explain to you what happens when the emotion of fear takes over in someone who has been abused, and that you, in those circumstances, the research is showing, go into an automatic state where you are not thinking. It is not a conscious thinking process on your part. You are merely responding, and your body is acting automatically. And you recall her testimony in that regard. And she was asked, this is a question from the transcript, let's talk about it in terms of fight or flight. Let's say somebody is coming at me to attack me. Their arm is raised, looks really angry. Now I've got to decide, my body's got to decide whether to fight him or to run. Now, what is going on biologically in this second stage when I'm being faced by this attack? She says, well, that's essentially when all of the hormones are spreading to tell the body to pick up two of these decisions of what you're going to do, make a decision. It generally is automatic because people begin to use, they are not even going to think because it's instinctual. The fear response is present in the body to protect the person from danger. So survival becomes the main goal, if you will, or why this whole system gets activated. So it is a physiological response to fear, and it is an instinctual response. You're not consciously thinking during this process, and she indicated that someone who had been abused was more likely to have that sort of an instinctive physiological response.
Very good segue into the use of the facts to support the argument and to get the jury to your position. he really hasn't hardly mentioned the facts at all. And so when he does, I'm going to notice. It's going to stand out. This is what he chose to emphasize. Testimony from the expert that basically fight or flight stage, you're in this fear mode, and that's happening at the amygdala level. That is not happening in the prefrontal cortex. You're not sitting and evaluating to yourself, should I feel scared? Should I not feel scared? And, given that I do feel scared, then, working yourself through like logically kind of what to do. It's not what happens. And somebody, does a jump scare you. You startle, you don't think about it. We've been in the lull, a little bit of the doldrums with the law. It's getting kind of boring, but now he's like snapped me back in because he's shown me why it matters. Why does it matter that we're going down this stuff? Well, because it's going to this question of what was his mental state. And here is some evidence about what his mental state was. And the state has to disprove that beyond a reasonable doubt. That's a pretty strong argument. Obviously got at least some of them. And so not like hammering on the facts kind of constantly and being very selective of it, I think is really doing a good job of just painting a very simple, easy to understand picture of what the defense wants me to do with this case and why. Here's your reason for why you think I should do something defense favorable. It's working for me.
That is one way in which the evidence concerning the abuse history is relevant to your decision here. It's not relevant to make someone look like a bad guy and therefore to try and encourage you to reach a decision that because Jose Menendez was a bad guy, we're encouraging you to adopt some theory of vigilantism here. The evidence was offered properly because one of the decisions you're going to have to make is, was Lyle Menendez acting intentionally or was he acting instinctively during this time period, during the final week, when his fear response and the reaction to what was going on with his parents was combined with his history of abuse. And one of the ways in which you would find that the killing here, although unlawful, was involuntary manslaughter would be if you decided that as a result of considering all the evidence, you believe that Lyle Menendez actually, but unreasonably believed that it was necessary to defend himself, and you further believe that he wasn't thinking, was not consciously intending to kill anyone. And in those circumstances, the verdict would be involuntary manslaughter because there is no intent to kill, although that killing is still unlawful. You will see when you look at the instruction on unreasonable self-defense, imperfect self-defense, a couple of things. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury kills unlawfully, but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person in the same situation, seen and knowing the same facts, would not have had the same belief. Such an honest but unreasonable belief is not a defense to the crime of voluntary manslaughter. It's also not a defense to the crime of involuntary manslaughter. And you'll see by this instruction that the belief can be unreasonable and that the crime is nevertheless manslaughter and not murder, even though a reasonable person in the same situation and seeing and knowing the same facts would not have had the same belief. So when Ms. Bazanich says to you, well, if we had known Jose Menendez was a child molester, we certainly would have prosecuted him. That really is missing the boat by a wide mark here, because the question is, first of all, Lyle Menendez had no idea who Ms. Pizanich was or what the practices of her office were or what the options were in terms of prosecution. The question is, what did the person even though you as reasonable people in the same situation, seeing and knowing the same facts, would not have had the same belief, you have to put yourselves in the shoes of Lyle Menendez and say, well, we have to view this from his perspective, his situation, in order to decide whether he actually had a belief in the necessity to defend himself against the threat of life or great bodily injury posed by his parents. And so to do that, you have to say to yourself, not what you as reasonable people would consider to be the right thing in those circumstances, but if you were in that situation with the history of abuse that Lyle Menendez had, was there something about his situation and his life history which actually caused him to have that belief? And if there was, then he's only guilty of manslaughter. Voluntary manslaughter if you found an intent to kill, and involuntary manslaughter if you found there was something less than an intent to kill. And again, the prosecutor harped on the fact that we attempted to show that Jose Menendez was an abuser here.
So much more evidence of that after the trial. The Menudo thing that came out, the band, the boy band, like, oh, it was terrible. Terrible. Like, no question in my mind. Yeah, Jose Menendez, sick MF. Okay. Not the point. Not the point. It's not he was asking for it kind of defense. That wouldn't be a good, sometimes you do. Sometimes, honestly, those are kind of fun, not in a murder. But assault, maybe something that he was asking for. It can be a somewhat fun defense to bring sometimes. But you're going to have a much harder time with mom being one of the victims in this case. Would not be a good strategy to pursue in this case anyway. But he's very, very forthright about that's not the point. It's about being able to sympathize with Lyle Menendez and put yourself in his shoes. Just the invitation. If the jury's willing to do that, like, you've already gotten a big advantage in the deliberation. Just being willing to put themselves in his shoes, asking them specifically, explicitly to do that might cause you some problems today, just because although maybe it is a little bit different because of the legal standard and the way it's phrased. Prosecutor cannot tell the jury, cannot argue to the jury, put yourselves in the shoes of really anybody. It's misconduct. It would be like, imagine your final moments, you're the victim, the final moment. No, you don't get to do that. It's like purely inflammatory, and it's not the legal standard and so forth. So you could see a situation where, like, maybe you're opening the door, but the general effect of it, to get people to think about what did Lyle Menendez go through and what kind of effect would that have. Imagine if I had gone through that, what that might be like. You've already won a huge part of what you're trying to achieve in the argument. Just seeing your client as a human freaking being with experiences and reasons for doing what they did that may not be good reasons, and they may be terrible things that they did, but at least try to see things their way. And then if you reject it, okay. But just giving it a shot, man, that is not always the easiest thing to accomplish.
And we did produce evidence in that regard as to both parents. The court will instruct you that that was properly received in this case. And the court's going to give you an instruction which reads, evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior. It may be reasoned that a person of such character for violent or abusive behavior would be more likely to act violently or abusively on any given occasion. However, evidence of such character for violent or abusive behavior may be refuted or rebutted by contrary evidence. Any conflict in the evidence of the alleged victim's character for violent or abusive behavior and the weight to be given to such evidence is for the jury to decide. And then the court's also going to instruct you. One who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual or threatened, than would be the person who would not receive such threats. If, in this case, you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. Now, what does that mean? That means that we're not just throwing dirt at Jose and Kitty Menendez in this case. The evidence was produced for you because under the court's instructions, you are obligated to look at Lyle Menendez's situation from his perspective and to say to yourself, well, if I was in his situation, if I had lived with these people, if I had suffered the kinds of abuse that he testified to that was corroborated by other witnesses, would I have some actual fear that my parents were about to harm me when I told them that I was going to disclose that he was a child abuser? And the parents, after that threat by Lyle was made of disclosure, then went through a series of acts, and those acts led to an actual belief by Lyle Menendez that his life was in danger. You have to be able, under the court's instruction, to put yourself in his shoes and to say to yourself, I can't look at this from the perspective of the reasonable person who didn't have that history. I have to be able to say, under these instructions, that he did not honestly believe that he was in danger. And the fact that the parents abused him and his brother in the past, the fact that they witnessed abuse in the past, the fact that they heard threats to kill other people is relevant in this case because it shows that Lyle Menendez had an actual, although you may decide, unreasonable belief that he was about to be killed by his parents. And the standard here is not whether a reasonable person would have done something else, like fled the house. All that questioning on cross-examination about why didn't you run away is really designed to address the question of whether it's an actual and reasonable belief, but it does not in any way address the question of whether he actually believed his life was in danger. And so you take into account the history of abuse in deciding whether he actually believed that certain things his parents did caused him to fear for his life. And that's why that evidence was produced. And you'll see under the instructions that I just read to you that the grounds for fear do not require actual danger, but only the honest belief of peril, and that the burden is on the prosecutor to prove beyond a reasonable doubt that self-defense was not justified, and that if a reasonable doubt exists, the defendant is entitled to the benefit of that doubt. And under those circumstances, you would be obligated to find that the most serious crime that was committed here was voluntary or involuntary manslaughter. A second way in which murder is reduced to manslaughter is sudden quarrel or heat of passion. And there will be a series of instructions about sudden quarrel and heat of passion. And you'll see under the instructions that there is identified the kind of passion that we're talking about that will reduce murder from manslaughter.
He's getting good at this board swapping.
Neither fear, revenge, nor the emotion induced by an accompanying or following an intent to commit a felony, nor any or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any or all of such emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately and from choice, rather whether such choice is reasonable or unreasonable.
I'm just going to pause real quick because I saw All Eyes' comment here and I wanted to bring it up to point it out. The degrees are very different from the way I understood them from Richard Allen's trial. They probably are because this is very much a state-by-state thing. How they differentiate between manslaughter and murder is very different. And like not every state has the heat of passion manslaughter, you know, as like a lesser version to murder. We don't have it in Washington. It's just a question of mental state. And so, yeah, you get a whole lot of variety state to state. And that's probably the main reason why this is not sounding familiar relative to the Indiana standard.
The interesting thing about this instruction is it talks about, first of all, the emotion of fear as being the basis for a heat of passion defense. And in this case, it is the defense's contention that the evidence in this case shows that the defendants, Lyle and Eric Menendez, were acting out of fear. And in that sense, the heat of passion doctrine is very similar to the self-defense principles that we just talked about. When you are relying on fear as a emotion under heat of passion, fear is very similar to the fear of death or great bodily injury. You'll see under the court's instructions that fear can serve as a basis for heat of passion, but so can other emotions. And interestingly, revenge is mentioned. And even more amazingly, the emotion induced by an accompanying or following an intent to commit a felony. So apparently someone can go into a liquor store and be excited about committing a robbery, and in the emotion of committing that felony, someone is shot. That killing could be, under this instruction, a heat of passion under certain circumstances, because the excitement of the moment is something that is taking over.
That's a little bit of an interesting argument. Don't love the example because, I don't know, myself, I'm thinking I'd probably be inclined to find murder in a robbery killing situation, you know, barring something like an accidental misfire or something along those lines. So it's like I don't emotionally connect with the outcome that he's explaining to me. But it is helpful, I think, still to kind of have some of these examples. Where I thought he was going to go with this was this is a little bit of the maybe moral, like you've got to be a moral certainty, right? That is part of the definition of reasonable doubt. There might be a little bit of a moral objection to, like, so you're saying that if I hate the guy enough that I, do the same act, but one is murder and one is manslaughter. I mean, that's what it sounds like to me. The heat of passion defense. I hated him so much that that drove my actions. I mean, it's voluntary manslaughter if I still have an intent to kill. This is where California's framework is a little different than mine, a little different from what I'm used to. And again, state by state, it can be very different. Intentional killing, where I'm accustomed to, is murder, period. Like, that's literally the distinction between murder and manslaughter. If there's a manslaughter, it's because you didn't intend to kill anybody. You just had, you were extremely reckless, or, some other reduced, diminished mental state. So I can intend to kill the person, kill them. And if I really, really, really hate them a lot, I'm guilty of manslaughter. But if I don't hate them nearly as much, I'm guilty of murder. It's like, it seems contradictory. That seems a little oxymoronic, And so I thought he was going to kind of like maybe flesh this out in a way to help me understand like how it makes sense. Maybe he'll get there. Like, morally, I should be okay with this, right? If I have to have a moral certainty, then my moral considerations and qualms kind of need to be dealt with. So maybe we'll see him get to that. I mean, the classic example of the heat of passion is the guy catches his wife in bed with some other dude, and that's the classic. Like, I'm pretty sure that's why it even exists as a defense, is because as a society, people decided we can understand his reaction. We can understand the provocation. And so even though we don't completely excuse it, you still shouldn't shoot the person. At the same time, we get it. That's a lot to expect a person to just take without any kind of reaction. But like a robbery and I shot someone isn't, I didn't like it. I didn't get the emotional clarity and resonance that I'm looking for in trying to sort out what seems to be legally a little bit incoherent. So we'll see if he manages to kind of make a little better sense of that.
And controlling that person's emotions, and even though the person is acting unlawfully, his intent to kill is formed as a result of the heat of passion, accompanying or following an intent to commit a felony. And under the law, that person could be guilty of manslaughter. Here, of course, you have a much less, how should I say it, sinister emotion, and the much less sinister emotion is the emotion of fear. But it's interesting, I think, because the prosecutor is claiming that the brothers acted out of, I'm not sure what she's claiming because there's been so many theories advanced as to motive, I can't keep them all straight. She originally began during her opening statement talking about money, financial gain, and there was also some talk about committing the perfect murder. And in the closing argument, we're now talking about camcorders and the desire to be free of the parents' control. So the issue of what motive is involved in these killings is not altogether clear.
What a good diss. Good little diss if we're going to be selective about the facts that we're talking about. And simultaneously, the defense only gets to talk once, right? So they got to rebut the prosecution's argument while they're making their own argument. Let's just go ahead and drop this in. By the way, they don't even have a consistent theory of motive, but at the same time, again, he's so classy with it. He's not like, he's not making it personal. He's not making it a thing other than just, look, it doesn't really make sense. They haven't quite figured it out, but we've got a pretty plausible explanation for you. And it's a single one, and it's a consistent one, that this guy has been abused his entire life in horrible ways. He's terrified of his father. And eventually they'd had enough, and he was scared of what the consequence was going to be. It's a good distinction. They're incoherent. They have 1,000 explanations because they can't actually figure it out and come up with the right one. But we just have the one because, ours is the simple one and the one that's right.
But under the people's main theory, the theory that they tried to advance throughout the case, the brothers were killing out of the desire to be freed of their parents' control. and there were questions asked on cross-examination along the lines of, isn't it true that you killed your parents because you were fed up with the abuse that was being inflicted upon you? Even under the prosecution's version of facts, if you were to decide, yeah, I think that's what the motive here was, that these brothers were killing out of being fed up with being abused and the control that their parents were exercising over them. Even under that interpretation, which we say is totally wrong, you could have voluntary or involuntary manslaughter because it would involve the emotion of revenge, either fear, revenge, or emotion induced by a company. And it goes on to say, any or all of such emotions may be involved in heat of passion. So even under the prosecution's version of the case, you can have voluntary or an involuntary manslaughter.
And back to the
There's
original.
several other principles about heat of passion that are important for you to understand. One of them is the court's going to instruct you that the passion necessary to constitute heat of passion need not mean rage or anger, but may be any emotion, including fear, which causes a person to act rashly and without deliberation and reflection. No specific type of provocation is required to generate the passion necessary to constitute heat of passion, and verbal provocation may be sufficient. If someone verbally provokes you, and as a result of that verbal provocation, you decide to kill that person, and you do it under circumstances where you don't have time to cool down, then that can be manslaughter, even though you kill that person unlawfully and you do it with an intent to kill. The court's going to give you some instructions on cooling period. And cooling period typically arises in a situation where the emotion being relied on is anger. If someone is angry at somebody else, that anger over time subsides. And the law says that if there's sufficient cooling period between whatever it is that provokes you and the time that you kill that person, then it would not be a proper charge to convict someone of manslaughter because you've had time to regroup and to get back your presence of mind. And as I say, typically that instruction applies in a situation where you have anger as the emotion. Somebody verbally provokes you, calls you son of a bitch, you get very angry, but you go out for a walk. You can't 20 minutes later, after your anger has cooled down, come back and shoot the person. That wouldn't be right, and that's murder, not manslaughter. But in this case, fear is a different kind of emotion, because fear, based on everything we know about it and experiencing it ourselves, is not the kind of emotion which typically cools down. In fact, it can grow over time.
True.
And so you have to keep that idea in mind when you consider this idea of cooling period, because cooling period does not work real well with some emotions, and fear is one of them. And the court's going to tell you that a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time. Now, what does that mean? Just like in the case of unreasonable self-defense, you can take into account the history between two people in deciding whether the person is acting in the heat of passion. If someone is your arch enemy and over a long period of time has consistently threatened or abused you, then it's more reasonable for you to act when that person threatens you again than it would be for someone who was just a stranger to you and you had no history with. That again is why the abusive conduct by the parents going way into the early years is relevant here. When Lyle Menendez talks to his father at age 13 about stopping the abuse of his brother, and the father says, it'll stop, and this is just going to be our secret, and don't tell anybody or I'm going to kill you. that's something which plays later on into whether Lyle Menendez was acting in the heat of passion when his father made the same kind of comments about whether he was going to allow Lyle to go out and reveal the abuse secrets to the world. So again, you take into account the entire history, and those will be gone into in some detail by Miss Lansing tomorrow. But it's important to realize again that abuse history and the evidence which you heard about the early relationship between the parents and the Menendez brothers is something which is properly before you so that you can decide whether these killings were committed in the heat of passion. So just to complete this chart, passion can be fear or any emotion that causes judgment to give way to impulse and rashness. No specific type of provocation is required. Verbal provocation may be sufficient, and it may be the result of a series of events which occur over a considerable amount of time. And again, the burden is on the prosecutor to prove beyond a reasonable doubt that the defendant did not act in the heat of passion. As you go through all of these decisions, you'll see that what you're primarily dealing with here is mental states of mind. That is, for murder, did the defendant kill unlawfully and did he kill with express malice aforethought? For first-degree murder, did he kill deliberately and with premeditation? Second-degree murder, did he kill, if there was no premeditation and deliberation, did he kill with express malice aforethought? For manslaughter, did he kill with the actual but unreasonable belief in the necessity to defend himself? And for sudden quarrel, heat of passion, did he kill out of a heat of passion? Was his intent to kill formed as a result of a heat of passion? All of those decisions require you to look at the mental state of Lyle Menendez, and the court's going to tell you that a crime is only committed when there's a joint operation of act, in this case killing someone, and a certain mental state in the mind of the person. So it's Lyle Menendez's mental state at the time of the killings, which you have to look into and decide, was he acting with malice? Was he acting with deliberation, premeditation? Was he acting in a reasonable self-defense? Was he acting out of heat of passion? All those decisions have to do with mental state. And mental state is something, because it goes inside someone's mind, that cannot be proved directly.
Gotta say this like a million times because it's just one of those things that's like always out there. Oh, the case is circumstantial, or this is circumstantial, or whatever. Pretty much every case is circumstantial for exactly this reason. You almost never get direct evidence of what is in somebody's mind. The one exception is when they confess and they tell you. But even then, false confessions happen, as we know. So it's like every case is circumstantial. You're always engaging in this kind of reasoning process to understand the evidence, draw inferences from what you can see about what you can't. And the most obvious one that comes up in any type of homicide cases is intent, because you're almost always dealing with intent through circumstantial evidence. How's he going to explain that?
Someone can talk about their mental state, but mental state is something that must be proven by circumstantial evidence. And the court's going to tell you that there are basically two kinds of evidence. Direct evidence, that's where someone sees something. Lyle Menendez testifies, I killed my parents. That is direct evidence. He was an eyewitness to the killings. Directly proves that he in fact did kill his parents. But his mental state at the time, he directly testifies to it because he testified that he acted out of fear, out of panic. That's a direct proof of what his mental state is. But generally, you are relying on circumstantial evidence to prove mental state. And there are special rules which apply to circumstantial evidence, which I'd like to talk to you about just briefly.
course he's got another visual.
As I said, the court's going to instruct you that circumstantial evidence and direct evidence are the same, entitled to the same weight. But he's also going to give you a special instruction on circumstantial evidence. And the circumstantial evidence instruction says, however, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible to two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Jurors often get confused about that last sentence, and prosecutors often jump on this last sentence and say, oh, that means that if Lyle Menendez's interpretation of the evidence is unreasonable, you have to reject it and find him guilty. No, because the evidence is still subject to proof beyond a reasonable doubt. It's the prosecutor's burden under the other instructions that I read to you to prove beyond a reasonable doubt that Lyle Menendez is guilty. And so this is an instruction which is given in connection with the beyond a reasonable doubt instruction. And it tells you that if you reach that point in your deliberations where you think, well, it could be one of two things. Either he did have malice or he didn't. It's equally plausible as to each. There's evidence to support each. His version is not unreasonable. Prosecution's version is reasonable as well. Under the instructions, it's your duty to find that the charge has not been proven. It would be your duty to find Lyle Menendez not guilty under those circumstances.
So again, with the just good explanation of here's how all this stuff applies in the case and why it matters, and here's something the prosecutor might try to go with, but really it's just about reasonableness and benefits of the doubt and so forth. And by the way, even if you think my position is reasonable, that doesn't mean guilty. All good points to make. I just can't help but notice like what a extremely favorable instruction this is for the defense from my perspective. This qualifying language about when you can convict on circumstantial evidence. I would love if there was like just a big study, some kind of comprehensive source for comparing jury instructions from all of the different states and how they all deal with all these different issues. I know that there are people that do it, academics that do it, and so forth, but just something accessible to be able to look at and mine and see patterns and stuff like that. Because I can say certainly in my state, the instruction is that circumstantial evidence is enough in and of itself. You don't have to have any direct evidence of anything. You can convict somebody entirely on circumstantial evidence. And while this qualifier is more or less true, it doesn't mean that's untrue. It just means that's part of reasonable doubt. And so they're not going to give an instruction, a whole special instruction on limiting the circumstantial evidence to tell you if you have reasonable doubt about, whether the circumstances lead to this conclusion or not. Then you have to vote not guilty. They just make me, the defense lawyer, argue that, so much of this, I think, is already just under California law and their procedures and stuff like that. Their form instructions. It's framed in a way that I think is giving them many advantages, but taking the opportunity to use those and spell out, here's why it benefits, even if You know, if you think we're both reasonable, then that's not guilty. That's pretty important. That's the bottom line. It's very simple, very easy to understand. Don't need a law degree to figure that one out.
And there's another instruction which applies circumstantial evidence, the rule that I just read to you, to mental state. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crimes charged or any lesser crimes unless the proved circumstances are not only consistent with the theory that the defendant had the required specific intent or mental state, but cannot be reconciled with any other rational conclusion. Also, if the evidence as to two such specific intent or mental state is susceptible of two reasonable interpretations, one of which points to the existence of the mental state and the other to the absence, you must adopt that interpretation which points to the absence of the specific intent or mental state. And then if, on the other hand, one interpretation appears reasonable, the other unreasonable, you must accept the reasonable, reject the unreasonable. This then is how you weigh circumstantial evidence which proves specific intent or mental state. And you'll see from this that the instruction directs you to look at the circumstances surrounding the commission of the act to decide what mental state was taking place at the time the act was committed. And that was one of the reasons why we presented the testimony of Ann Burgess, because her testimony was directed to the circumstances surrounding the act, and specifically the crime scene evidence, and what can be inferred from the crime scene evidence as to whether the person who committed whatever happened there that day was acting with deliberation or premeditation, was acting carefully after weighing the decisions for and against, or instead was acting out of fear, and do the circumstances of the crime scene point in one direction or the other. And you recall Dr. Burgess was a person who has been working with the FBI for 10 years as an expert on victims. And it's been her expertise, and her life has been devoted to helping law enforcement develop ways to better understand how to catch people who commit crimes by looking at the crime scene. When the prosecutor refers to her as a hired gun, I find that incredible in light of this person's background and training. This is a person who is affiliated with law enforcement. She's worked with the FBI, still works with the FBI, and she was the one who was responsible for the crime classification that the FBI uses to catch criminals. And yet she is painted as a hired gun along with every other expert in the case who you're supposed to just completely reject and not put any weight on whatsoever. And I think a fair judgment as to Dr. Burgess is that she's an incredibly qualified person. She's someone who offered testimony, I think in this case, which was helpful in analyzing the crime scene, as well as analyzing what the effects of fear are. And she's someone who is not subject, I don't think, to a fair charge that she's simply a person who would come into a court of law, take an oath to tell the truth, and lie because she was getting paid money. And that's sort of...
You call someone a hired gun when you don't have your own hired gun, right? It's like, oh, they have a hired gun because you didn't have somebody to contradict it. Not sure. I don't know how that evidence went in the Menendez case. I don't know if they had a rebuttal expert or not.
Broad-brushed attack on our defense witnesses, I think, needs to be carefully looked at by the jury, because I think it's an unfair attack, and I think it really attempts to minimize the importance of the expert testimony which was presented to you and which, as you'll learn under the court's instructions, was properly presented to you. Sometimes experts can contribute something that we as common folk don't know about. And I don't know about you, but I have not spent a lot of time analyzing crime scenes or talking to serial killers or researching victimology as Dr. Burgess has. And I think she did have something to contribute to this case. She was asked her opinion of whether the crime scene in this case was an organized or a disorganized crime scene under the criteria used by the Federal Bureau of Investigation.
Disorganized.
And she said,
Really?
the question was, and in applying these guidelines and analytical methods to the crime scene here, did you reach a conclusion about what kind of crime scene this was? Answer, yes, I did. And what was that? Answer, and I'll preface it, if there may be indicators of both organized and disorganized, but generally in this crime scene, I saw more evidence of disorganized organization. Question, and did that indicate to you a lack of planning to avoid detection? Answer, yes. Question, and does it appear to be a disorganized crime scene because you cannot see any significant evidence of planning to avoid detection? Answer, yes. Question, now, what under the FBI's criteria, what was disorganized about the crime scene? Answer, location, choice of weapon, injuries to the victim, emotionality, indicators of emotionality, and lack of staging. And she went on to explain how the use of the particular weapon, in this case a shotgun in a busy residential area, was an indicator to her as an expert and as an analyzer of crime scenes that this was not a real carefully thought out, well-planned, deliberate, premeditated scheme going on here, given the fact that this was numerous shotgun blasts shot off in the middle of a Beverly Hills neighborhood. And she,
If I remember right, I don't know the facts of this case super well, but if I remember right, okay, they shot and they decided to go, like nobody came, nobody responded. And so they decided they were going to go, like, I guess set up their alibi. And so they left to go to the movies and then came back. And when they came back to the house, the police were there, but they still had the shotgun in the trunk. This is kind of what I remember. You guys let me know if I've got the basic facts wrong, but it's yeah, I mean there's a lot to deal with when it comes to this whole like disorganized, organized characteristic and kind of what it means and all of that type of thing, and sorting out what's noise from what signal. But you have that kind of complicated by just a tendency to impulsiveness anyway when you're younger and teenager, emotional, whatever, there's like a lot of crossover with these types of things. I doubt they're gonna get real into that, in part because I don't know that it particularly helps their case, but also this just it nowadays talking about youth and brain development and stuff like that is kind of par for the course, but I don't know that was necessarily the case back in 1993.
Also talked about injuries to both parents, and this goes to the coroner's testimony as well, describing the pattern of injuries that he described on both Mr. and Mrs. Menendez. Question, now you said the third factor leading to a characterization of disorganized was the injuries to the victims. And what do you mean by that? Injuries to victims is that you look at where on the body in a gun shooting case, where the injuries are, not only where they are on the body, but the number. And why does that tell you something about organization versus disorganization? Answer, more organized type of of person who shoots is going to use the minimum amount of shots to accomplish the task. She then went on to describe emotionality and why that was an important consideration. And she said that the term emotionality is sometimes used overkill, that there is a large, more shots are fired than is necessary to accomplish the task. And that was a situation in this crime scene, that a large number, far more shots were fired than were necessary. And she was asked, in this particular case, what analysis did you come up with concerning where the injuries were on these two decedents? She said, my analysis is that the injuries were random, if you will. They were to all parts of the body. There was not one area singled out. Question, what conclusion based on this analysis could you draw? Answer, well, that would speak to a more pervasive emotion than just one emotion, such as anger or rage or what, but would speak to a wider aspect. Questions such as, she says, such as fear. And then she went on to describe how the presence of the absence of shells and the presence of the absence of a weapon at the scene was an indication of an organized crime scene. But she pointed out that there was a difference in organization, post-crime planning, planning during the crime, and pre-crime planning. And you'll see under the court's instructions on first-degree murder that what the law is concerned about is pre-crime planning, because deliberate, premeditated murder is committed when someone before the murder carefully weighs and considers the question of killing, and after carefully weighing and considering the reasons for and against the killing, they go ahead and make the decision and kill.
So important distinction and good one. And I hope this gets fleshed out, because it's the difference between I planned to do the crime and figured it all out and figured out the best way to do it. And my cover up is part of that, because of course nobody wants to get caught for doing something like this, versus, oh shit, I did something and then I freak out and try to cover it up. There's a big difference in them under the law, but like, what do they look like, relatively speaking? I'd like to see us get a little bit more of the facts here. If we're going to get into that, if he thinks that's appropriate, but because I think that is a really important distinction. How is the proof of stuff like the fabricating the alibi and how is that inconsistent with this being a premeditated crime? Like what else is there? Why does that not get us there? We'll see if he does.
If after that decision is made and the person kills somebody and then does something else, then they're into the post-planning period, and it can be subject to two reasonable interpretations. For instance, if someone kills in the heat of passion, you kill someone because they've abused you and they've just made a remark to you which is threatening, and you go ahead and kill that person. You shoot them someplace where no one else is around, and you realize, I just killed unlawfully. I know I just committed manslaughter. I don't really want to go to jail. I'm going to do something to hide this crime. You hide the gun, or you bury the body, or you leave the jurisdiction, or you take money from the person and you spend it. You have to be careful, because what you do after the crime may very well reflect on what your state of mind is days or minutes or months after the crime.
And that's kind of important, what happened in this case, isn't it? The actions in the aftermath of the murder, kind of important in this case. I don't know how much he's going to get into it, or just leave it for the co-counsel who's going to get into more of the facts. But like, that was, I think, one of the biggest problems they had was the shopping spree. The fact that they went out and started like buying all of this stuff with the inheritance. It's not a good look. And surely if you had planned things out ahead of time, you would have known not to do that. But maybe you're just not a good planner, you know?
But it doesn't necessarily tell you a whole lot about what you were thinking at the point in time when the trigger was pulled. And that's the point in time when the law focuses you on, because that's the point in time when, if a crime is committed, there has to be this union of act and mental state. So it's pre-crime planning that the law looks to. And Dr. Burgess attempted to analyze a crime scene in such a way that you would be able to look at it and say, what is there about this crime scene that points to deliberation, premeditation, or malice? Does it point to that, or does it point to something more in the nature of fear and heat of passion? Now, you may give the prosecution the benefit of the doubt and say, I think the crime scene points to premeditation and deliberation. That's one reasonable interpretation of the crime scene. You may also say it's equally reasonable that because of the way the crime scene looked and the circumstances of that crime scene, it's just as reasonable to infer fear and heat of passion from that crime scene. And under the court's instructions that I just reviewed with you, it would be your obligation to accept the interpretation which pointed toward innocence or to the lesser included offense and find Lyle Menendez not guilty. And that's an illustration of how circumstantial evidence is used in this case. I want to talk briefly, and I want to try and finish today, so I don't want to go too much longer. Briefly about the testimony of Dr. Oziel. How else do you prove that someone's mental state was what it was at a given period of time? You can do it through statements of the defendant. And the court's going to give you an instruction on what the law calls admissions or confessions. If someone says to someone else, I killed this guy and I did it with express malice aforethought. He's not going to use those words, but he may say, I did it with the intent because I wanted to kill that son of a bitch. And that witness comes in and testifies to that. That's a pretty good indicator of what that person's mental state is, if two things can happen. Number one, in that situation where some person's coming in and saying, this other person made a statement to me, the question for you as jurors to decide is, number one, was the statement made? Did the person hear it correctly? Is that person honestly reporting to us what was said by the other person? And then the second question is, if the statement is being accurately related to you, is the person who's doing the speaking truly as to what their intentions are? Because if the person is not speaking truly as to what their intentions are, then the statement is not a very good indicator as to what the person's mental state was at the time of the crime. And that type of analysis applies to the testimony of Dr. Oziel in this case. The prosecutor attempted to deal in her closing argument with Dr. Oziel by saying, well, the defense is going to say he was our star witness, but really the only reason we called him was so that he was a witness that we had to call in order to prove that it was the defendant who was the killer, to prove the question of identity, not the question of motivation. And the only importance of Dr. Oziel was that he testified that Lyle Menendez admitted to the killing, and he had to be called because we had to prove as prosecutors beyond a reasonable doubt that he was the killer, even though the defense says that they conceded that that was the case. That's a very interesting way of dealing with Dr. Oziel, because when the case began, the prosecution went into his statements at length during her opening statement. And she went into him at length because she was relying on him at that point, before any evidence was offered, to try and show to you, to prove to you what Lyle Menendez's motivation was. And you recall from the opening statement that at the beginning of the case, she was claiming that the evidence would show that Lyle Menendez's motivation was that he and his brother were committing the perfect crime, and that was proved up by the testimony of Dr. Oziel. And she also indicated that the evidence would show that they did it out of hatred, out of greed, and various other motivations that she attributed to the killings, but they all centered on Dr. Oziel and what Dr. Oziel was supposedly going to testify to. As it happened, Dr. Oziel sort of disintegrated as the case progressed. So by the end of the case, there's really not a whole bunch left of his credibility, and I don't intend.
Oh, now I need to know more about Dr. Oziel. I don't know this part of the story. It sounds juicy. But I have to say that as far as like planning the perfect crime, that seems like a terrible approach, just given, even the relatively little I know about the case. It just, in what respect would it be perfect? I don't know. I don't know. I mean, they didn't even really nail these guys until they went and blabbed to their psychiatrist, right? Who then like turned around on or their lawyer. It was their lawyer? It was somebody that had like a privilege. I don't remember enough of the details. Anyway, they didn't like the kids for going on the shopping spree and all that, but didn't have them connected to it until they went and blabbed. Yeah, I don't know. I don't know about the perfect crime angle.
And to spend a lot of time on it. You heard the evidence, and you heard all the evidence in regard to his credibility. I agree with Ms. Bizanich, this is not divorce court, but Dr. Oziel was offered to you, at least according to the opening statement, as a witness who was going to prove the motivation for these killings. And it became important to show whether he was telling the truth or not.
And so was Dr. Oziel, was he the psychiatrist, the one that, recorded them secretly having a fling with his secretary or something? There's like such a crazy story with that guy. It must be him. That must be who Dr. Oziel is.
To what he heard. And of course, if he heard what he says he heard, then that would put someone in fear. If someone comes in to you and says, yeah, we killed our parents and I'm going to kill you, Dr. Oziel, that would put somebody in fear, and you would expect someone who had received that kind of information to act like they were in fear. So we explored with you what Dr. Oziel's behavior was after he supposedly received that information, to see if in fact he was acting like a person who was in fear for his life or had been threatened. And all the testimony about his behavior went to show that Lyle Menendez's testimony about what he told Dr. Oziel is the more believable of the two witnesses here, because he denied ever threatening Dr. Oziel. He denied most of the outrageous statements that Dr. Oziel said were made to him. And Dr. Oziel supposedly said these statements were made to him after he had warned Lyle Menendez. Now remember, Lyle, if you threaten me, what you say to me is not confidential. And according to Dr. Oziel's version of it, it was after telling Lyle that he was not subject to confidentiality that Lyle Menendez went ahead and threatened Dr. Oziel, and not only threatened him, but supposedly, according to Dr. Oziel, signed on to a version of first-degree murder. Because you remember, according to Dr. Oziel's testimony, he offered him two options, which incredibly are almost verbatim the legal definitions which you are required to decide here. Review Dr. Oziel's testimony, and he's got Lyle Menendez faced with the choice of, Lyle, is this heat of passion or is this premeditated or deliberate killing? And according to Dr. Oziel, he signs on to the premeditation deliberation package. This is supposedly after Oziel tells him that what you tell me is not confidential. Well, if he had signed on to that version, would you expect Dr. Oziel to be acting the way he was acting in the days and months following receiving that information? And the tape recordings, which were played for you during the testimony of Ms. Smith, and whatever you think about her credibility, the tape recordings have the voice of Dr. Oziel on them. They were offered to show that Dr. Oziel, first of all, lied to you about several things, and second of all, that he was not someone who was in fear of anybody during this period of time that he said he was in fear. So the first question with respect to Dr. Oziel is he testifying truthfully about what was said? And I think you have to look as who this man is. He is a psychologist, a certified sex therapist, who at the time he was counseling the Menendez brothers was on probation for having a dual relationship with his clients. And he was on probation from 1988 to 1991. He was on probation during the time that these conversations supposedly were overheard by him.
He was on probation for having dual relationships with his clients, and he's having a dual relationship with his client in the context of this very case. What's the matter with this guy? Thank you for telling me this, Mr. Burt. I knew he was bad, but I didn't realize how deep the rabbit hole went.
And at the time he testified at trial, he was under accusation by the Attorney General's office for, again, dual relationships.
Well, yeah.
So as he's sitting here testifying, you have to wonder what his motivation is for not telling you whether, in fact, he was attempting to somehow manipulate the brothers or manipulate other people for his own benefit. He's certainly not going to admit and therefore jeopardize his license, which is under question because of the present accusations, by saying that Miss Smith was his patient. And yet there's evidence in front of you that he's writing excuses for her for court that, based on one falsification of the excuses that he gave, that he was considered for prosecution by the same DA's office that's prosecuting this case, and the prosecution was rejected for statute of limitations problems, whatever those were. But I think you have to consider, is Dr. Oziel telling you the truth? What this man's motivations are? And is this a person who has his own agenda here to save his license? Did he have an agenda at the time these events he's testified to are taking place? Was he attempting to manipulate his girlfriend and his wife by using some information he had received from the Menendez brothers in order to control and manipulate these women? Is he the type of person that preys on people like Miss Smith or preys on people who were in unfortunate circumstances? Was he attempting or in the process of following his MO of preying on people when he on his own contacted the Menendez brothers in the days following the murder, and when he later tells Miss Smith, get out of here, Judulon, there's $14 million involved in this? What are his motivations?
This is a very clean murder of Dr. Oziel. Not pulling any punches, but he hasn't raised his voice a single time. And he's kept it pretty factual. I mean, yeah, I'd say there's a lot of questions about the doctor, just with the limited amount I know about it. But he's sticking in the knife right now, but he doesn't seem real unpleasant, aggressive. Doesn't seem like a bad guy for doing it. I read anyway.
Is he a clean witness in this case? And I think the answer is clearly not. And I think in response to the answer being clearly not, the prosecution has to bail out of Dr. Oziel. He's no longer the star witness, because to make this case depend on Dr. Oziel's credibility is to make it depend on quicksand. So now the star witness becomes Perry Berman. And the reason it's explained to you that Perry Berman is the star witness is because he had a conversation with Jose Menendez, and Jose Menendez said he was going to help Perry Berman out. And since he said he was going to help Perry Berman out, doesn't that indicate that he was not contemplating killing Lyle Menendez? Well, the question here is not whether Jose Menendez was in fact plotting to kill Lyle Menendez. That's beside the point. The question here is, did Lyle Menendez actually believe, as a result of what he saw and what he heard and the history he had undergone with Kitty and Jose Menendez, did he actually believe he was in danger? So how Perry Berman and the woman from the sporting goods store all of a sudden become the star witness and Dr. Oziel is dropped from the spotlight, I think is apparent. It's an attempt to bail out of a very uncomfortable situation where the prosecution's star witness has turned into not so much of a star after all. The two other issues I wanted to discuss with you, and I know it's late. Briefly, the testimony of the coroner. The prosecutor asked or posited that we had not shown to you, we had not proven to you, as if it's our job to prove to you, which it's not, how Jose Menendez obtained the shot through the thigh. And she then speculated that she thought that the shot to the thigh took place when, if I understand it, he was already sitting down and the leg was somehow up and moving. The coroner testified that all of the, first of all, Miss Bazanich's arithmetic is a little off here. She gives a little benefit of the doubt as to Mrs. Menendez and says, well, let's assume there were 7 wounds. And as to Mr. Menendez, let's assume there were 5 wounds. And there were 2 shots through the door. That makes 14. We know the guns hold 6. Therefore, there must have been 2 shots on the reload. The problem with that arithmetic is that the coroner testified that the number of wounds does not mean that that corresponds with the number of shots. And the reason for that is that he indicated that some of the shots could have been what he talked about as pass-through shots. That is, some of the shots, and some of them were distant shots, where some of the load from the pellets could have gone in Mr. Menendez, some could have gone in Mrs. Menendez. He also testified that it was possible that there were pass-through shots, that some shots passed from one person to the next. So the fact that there are 7 wounds does not mean that there were 7 shots. The fact that there were 5 wounds on Mr. Menendez does not mean there were 5 separate shots. So the arithmetic doesn't quite work. But aside from that, the theory of the prosecution, as I understand it, is that he is somehow sitting down when the leg wound, the thigh wound, is inflicted. I don't think that's the way it could have happened, because the coroner said, and she also indicated that the wounds to the back of Mr. Menendez must have been inflicted when he was already seated down. I think the coroner was pretty clear in testifying that the wounds to the back of the elbows of Mr. Menendez could not have been inflicted looking at the photograph in the way in which he was seated down, because the arms are covered by the couch, and the only way that could have happened is if you shot through the couch. I think if you asked to have that portion of the coroner's testimony reread, if there's any doubt about that, and that's generally what we do if there's some question about the evidence, that you'll see that the coroner was very clear that the wounds could not have been inflicted to the back of the arm when he was on the couch. And I think he was also clear that the leg wound could not have been inflicted when he was seated in the position that he's shown in the photographs, because the leg wound to the thigh was a shot that went from the inside of his thigh to the outside of his thigh. And he indicated that since there were no pellets found inside the wound, that the shots would have been blown out the outside of the leg, and there would have been some sort of particle, blood or pellet particle, either on the couch or in the area immediately to the left, if he was seated in the position in which he is shown in the photographs when he received those injuries. And you'll see from the photographs, there is no particle or any sort of markings to the left of Jose Menendez's leg. So it could not be that he was seated. By the same token, the coroner also testified that the wound to the leg probably would have been incapacitating. So one possibility here is Jose Menendez, as you recall from Lyle Menendez, testimony and also Eric Menendez's testimony, was moving toward him at the point in time when the doors were burst open. And one possibility here is he has his arms up in some way, and he is shot in the back. And the coroner said the fact that he's shot in the back does not mean somebody's standing behind him, because if someone is moving their arms in some way, the shot could come into the back, and yet the shooter could be facing you. One possibility here is Lyle Menendez shooting from the door area into the back of the hands. Eric Menendez, meanwhile, according to his testimony, is moving from the doors around to the area in front of the TV, and according to his testimony, is just firing, randomly firing. There are shots into the French doors, two random shots that go through the French doors. There is exhibit number 17 are the pellets which were recovered by the coroner. And you recall the firearms examiner said that there were for buckshot, there were, according to his analysis of the evidence that was found both in the coroner's examination and evidence found at the crime scene, he indicated that there were 6 shots, at least 8 shots fired, 6 shots of buckshot and 2 shots of birdshot. And he said that the buckshot that was used contains 27 pellets per round. And he was asked if 6 loads of buckshot were fired with 27 pellets, would that mean 162 buckshot pellets and 6 rounds? He indicated that that would be the case. Only 56 of those pellets were recovered. I believe it's exhibit 16 or 17. The actual pellets recovered by the coroner are in evidence. He indicated, I believe, that he did not recover all of the birdshot pellets. Some of those birdshot pellets were left in the bodies. But as to the buckshot, I believe he testified he recovered all the buckshot that he could. Maybe an error on that, but I think he said he recovered all the buckshot that he could from the bodies. And if you sat down and went through those envelopes, you would see that there are 56 pellets recovered, 56 individual buckshot slugs recovered. And if 6 shots were fired, that means 162 minus 56 did not hit the target. And we also know that there were 2 shots through the windows, which would indicate that there was some random shooting there by someone. And so one possible scenario here is Lyle Menendez shooting at a point in time when Jose Menendez is up and about, hits him in the back of the arms. At the same time, a shot coming in from the area of the TV from Eric Menendez through the left thigh, and the particle going out through the leg into the same area of the couch, which is covered by blood. And if you look at the portion of the couch where Jose Menendez was seated, you'll see blood in that area where he was seated. The shot blows out into the back of the couch. The shot to the leg incapacitates him, and at the same time, Lyle Menendez is coming forward, and the last shot in time would be the shot which was the contact shot to the head, which he indicated took place very quickly after the first shot was fired.
We've reached the point now where I just want to go back and like think fondly back on the parts of this argument where he was very selectively using facts to illustrate his point, because I've lost track of the point. I don't know why any of this matters. We were making our way through the crime scene and the characteristics of the crime scene and what we could ascertain about the defendant's mental states from that crime scene. Is it organized? Is it disorganized? Is it chaotic? Does it look planned? Does it look less so, more impulsive or whatever? And so, like, I think that's still where we are, but we've just gone kind of far down the road here of first the Dr. Oziel sideline, which is fun, and I enjoyed. Like, oh yeah, totally forgot about that whole side of this case, because that was some crazy stuff. But now, like, this very detailed analysis of the shooting and everything, and it probably does matter, but I've lost track of why. And so, it's late in the day. It's late in the day, and he's been talking for what, hour and a half? Well, over an hour and a half. It's got 20 minutes to go. So, could just be running out of steam, could just be like losing track of how this is relating. Maybe me, I don't have a very good perspective because of course I didn't sit through all 85 days of evidence in the case, but the bottom line is that by the time you set through 85 days worth of evidence, some of it's stuck and some of it hasn't. And I don't know. I'm not quite sure why any of this matters. I just this is like my first time. I'm gonna be kind of critical. Like, I would like this to be more refined. I would like to understand, why does it matter what position Jose Menendez was in when he was shot in the back of the arm? Like, that's really all that matters. I need to know, why does that matter? Because I'm lost now on a lot of these details, and I think we're going to come back to mental state, but I'm just kind of not sure. And so, I forgive him. It's a long argument, whatever. But I feel like we're off track, so I hope we get back on.
And the coroner also indicated that the sequence of these shots must have been very rapid. And he thought that the shots were very rapid because all of the wounds that he examined were anti-mortem wounds. And since some of the shots were fatal, the fact that there were no post-mortem wounds meant to him that all of these shots must have been fired in very quick succession. That testimony is also consistent with the testimony of the neighbors who heard firecracker-type sounds, which were not interspersed by a great deal of space. So as to the defense not explaining exactly how this shot was inflicted to the leg, I think there is a reasonable interpretation of the evidence which would show how that shot was inflicted. And in any event, I don't think it's our burden to show how one shot or another was inflicted. The burden is on the prosecution. And then lastly, I wanted to talk briefly, because of the importance of the question about the special circumstance allegation. And I hesitate to even talk about this because it's our very strong position in this case that, based on the evidence that you've heard and based on proof beyond a reasonable doubt, that by the end of your deliberations, you should be on this side, the left-hand side of this decision tree, not on the right over here. But because of the obvious consequences of a finding of special circumstances in this case, I want to talk just briefly about the two special circumstance allegations and also the charge of conspiracy. And I'll talk about the conspiracy charge first. And the reason I said earlier that the conspiracy charge and the murder charges require you to decide the same things is because of an instruction the court is going to give you about the conspiracy charge. And first, the court's going to tell you that a conspiracy is an agreement entered into between two or more persons with a specific intent to agree to commit the public offense of murder or manslaughter, and with a further specific intent to commit murder or manslaughter, followed by an overt act committed in the state by one or more of the parties for the purpose of accomplishing the object of the agreement. It's a very hard definition to follow. But you may ask yourself, well, if someone meets with someone else, and again, I challenge the prosecution to point to when the agreement was formed in this case. When was there a meeting of the minds between Lyle and Eric Menendez where they got together, and the court's going to say she doesn't have to prove an express agreement, but still an agreement must be proved to show that a conspiracy exists here. When did the conspiracy get formed? When did they come together, and what was the object of the conspiracy? And I challenge her to pinpoint for you what the charges are so that you can decide whether that charge is true or not. You may ask yourself, well, how can somebody come together and agree to kill somebody and not have that be a premeditated killing? Because if you agreed with somebody else in advance that the killing was going to be premeditated, that you were going to kill somebody, wouldn't that be murder in the first degree? And the court's going to give you an instruction about that, which says the fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted with malice or with premeditation and deliberation. If, as a result of heated passion, sudden quarrel, or an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, a man kills without malice, he commits murder. It necessarily follows that if this same man, under those same circumstances, conspires to kill, he conspires to commit manslaughter. So you'll see under this instruction that this instruction requires you to go back to the evidence again and decide whether any agreement that did exist here, was that an agreement to kill which was formed as a result of heat of passion or the honest but unreasonable belief that someone was about to kill you. Because if two people think that they're about to be killed and they come together and say, you know, we're about to be killed, we got to do something about this, that may be a conspiracy. May not be, but it may be a conspiracy, but it's only a conspiracy to commit manslaughter, not a conspiracy to commit murder, because the agreement is formed upon the heat of passion or the unreasonable belief in the necessity to defend yourself.
These are such bad facts that, again, just like getting the hung jury is so impressive to me, because like when you're arguing that two people with guns, like they had guns and agreed spur of the moment, we need to do this because of our fear. I mean, it's not real plausible. It's not real plausible to me. I mean, I don't know if there was an agreement or not. I don't know what the evidence was of any agreement. There was just, action in concert. I guess that implies some kind of agreement. That makes it so hard for me to get out of the, at least that was planned. The just showing up with a shotgun alone was planned. That didn't happen spontaneously. And so to get as far as they did, I mean, they either had like the best, most pro-defense jury on the planet, which I guess is possible. You do get lucky sometimes. Or they just really knocked it out of the park with what they did have to work with, and just raised enough questions to get the jury disagreeing about what they thought actually happened, and in a way that nobody was going to move off of their opinion. Just hearing him kind of put it like that. There's an agreement, it's just okay, but yeah, but an agreement based on a heat of passion. I mean, it seems so inconsistent too. Like, isn't the whole point of the heat of passion that you are not thinking critically? Like, isn't that he just made the argument from their own expert? The fear like overrides. So are you going to make an agreement? I don't know. I don't know. I mean, I'm super impressed that with facts this bad, they were able to get a result that good.
And then lastly, the special circumstances. As I indicate, if and only if you decided the charges were murder and a charge was murder in the first degree, would you get to the decision of true or not true, the special circumstance. And the rules for special circumstances are exactly the same as for the charges. That is, they must be proved beyond a reasonable doubt and to a moral certainty. If they depend on circumstantial evidence, the same rule applies that if there are two reasonable interpretations, your duty is to adopt that interpretation which points toward innocence. And you'll see from the instructions that the exact same rules apply, obviously because of the consequences which follow a finding of true to the special circumstance allegation. Two special circumstance allegations that are charged in this case are multiple murder. And the court's going to tell you that to find the special circumstance referred to in these instructions as multiple murder convictions to be true, it must be proved that the defendant has, in this case, been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree. All right? Now, what that means is, suppose you looked at the evidence and you said, and I'm not suggesting you do this, I'm using this hypothetically because I want to illustrate the multiple murder special circumstance, but suppose you decided after viewing the evidence that Lyle Menendez was guilty of the manslaughter of Jose Menendez. Mm-hmm. And suppose, or he was guilty of second degree murder of Jose Menendez. As to that charge, you would stop because you would not have found it first degree murder. But suppose, just hypothetically, that you went back and you said, but I think as to Kitty Menendez that it's first degree murder. If you found that, and again, I am not in any way suggesting that that's a proper verdict, I think it is not. But if you were to find that, then the question would be, is the special circumstance of multiple murder true? If you had found that the charge as to Jose Menendez was manslaughter, then the multiple murder special circumstance would not be true, because in order for it to be true, the second murder would have to be murder, first of all, and it would have to be in the second degree. And you could switch it around. Suppose you found that as to Kitty Menendez, Lyle Menendez was only guilty of manslaughter. As to Jose Menendez, he was guilty of first degree murder. That would not, the multiple murder special circumstance would not apply there because you would need a second degree. It's only if you have a first degree and a second degree, or two first degrees, that you could find that the multiple murder special circumstance would be true. And I hope that that's clear. And that in turn goes back to the instructions that we've been talking about all afternoon. In order to find out whether it's first degree murder, you have to go through the analysis that I outlined in the charts. And it's only if you reach that point of finding one first degree and at least a second degree that you could find that the special circumstance would be true. And in that event, we'd have to have the second trial where you would decide the question of penalty. Suppose you found that the charge as to Kitty Menendez was manslaughter, the charge as to Jose Menendez was first degree murder. Of course, it was second degree murder and manslaughter. That would be the end of it. There would be no further determination of the special circumstance allegation because you'd have a second and a manslaughter. And under the chart, you'd end right here. It's only if you found, for instance, a manslaughter and a first, and in that situation, you'd say, well, the multiple murder special circumstance isn't true because we don't have a second. So you would find that to be not true. But your job wouldn't be over because the second charge has been made in this case, and that is the charge of lying in wait. And the special circumstance of lying in wait while lying in wait is a little bit more complicated than the multiple murder special circumstance. And I want to spend just a minute on it, and then I'm through. The instruction says to find that the special circumstance referred to in these instructions as murder while lying in wait is true, each of the following facts must be proved. Number one, the defendant intentionally killed the victim. Number two, the murder was committed while the defendant was lying in wait. The term while lying in wait within the meaning of the law of special circumstance is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. Then the instruction goes on to talk about what the term while, that part of the instruction tells you what lying in wait means. That is a waiting and watching together with a concealment by ambush. Now the instruction tells you what killing while lying in wait means. And it says, thus, for a killing to be perpetrated while lying in wait, both the concealment and watchful waiting, as well as the killing, must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. If there is a clear interruption separating the period of lying in wait from the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. It's a little bit confusing, but what that means is there are two requirements here: concealment, lying in wait, and that the lying in wait occur while the and that the killing occur while the lying in wait take place. And the instruction then sums up what the elements are, and it says, a mere concealment of purpose is not sufficient to meet the requirement of concealment set forth in this special circumstance. However, when a defendant intentionally murders another person under circumstances which include, and now it sets forth the elements that you have to find. Number one, a concealment of purpose. Number two, a substantial period of watching and waiting for an opportune time to act. And number three, immediately thereafter, a surprise attack on an unsuspecting victim from a position of advantage. The special circumstance of murder while lying in wait has been established. If the murder is done suddenly, without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. So there are two things here. If someone is waiting and watching, and there's a time period between the waiting and the watching and the killing, then the special circumstance is not true, not because there wasn't waiting and watching, but because the killing was not while the person was lying in wait. It has to be both while lying in wait, and there has to be a substantial period of waiting and watching before the killings take place. That's an important distinction to remember in this case, if you ever got to that point, and God hopes that you don't, but if you ever got to that point, keep in mind that there are two requirements. It has to flow continuously from the period of waiting and watching into the killing. Otherwise, it's not while it's lying in wait. And if there's an interruption, then the special circumstance is not true. But more importantly, even to get that far of whether it's while lying in wait, you have to determine that there was a substantial period of waiting and watching for an opportune time to act. That's what a lying in wait means. And the ambush, when Ms. Bizanic says, well, as classic lying in wait is where I lie in ambush for you. I wait and watch for you, and when you come by, I kill you. That's classic lying in wait. And she said that she doesn't need classic lying in wait because the killer can come to you now. Well, that's not true. It still is required under this instruction that there be a substantial period of waiting and watching. Otherwise, the special circumstance is not true. And in this case, the prosecutor attempted to prove that charge by cross-examination of Lyle Menendez and by cross-examination of Eric Menendez. and they failed to prove it. And Lyle Menendez on direct examination was testifying about the moment in time when he was in the car and the guns were being reloaded prior to going into the house. And he said, I just grabbed a bunch of ammunitions out of the box and I was giving him Eric ammunition and we were just loading as fast as possible. Question, do you remember how many shells you loaded? I don't remember. I remember pulling out all kinds of shells and just loading my gun and having shells on me. Question, what did you do then? We went, my brother, I guess, had got outside through the study doors because he ran toward the study window door. And you had to kind of go over this. I think you had to, we went over the little concrete thing. It was over to the side of the door on the left. And we went through that door and we just went into the room hoping to get there when they were not expecting us. And on cross-examination, Ms. Pizanich asked Lyle Menendez in order to establish that there was a substantial period of watchful waiting. Question, now I take it before you and your brother burst in to kill your parents, you looked through these doors to see what they were doing. Answer, no. We weren't even sure that they were going to necessarily be in that room, but I was hoping. We just burst through the doors, and that's when I saw the shadows of people to the right, and I knew that they were in the room. Question, did you ever think to go into the kitchen and look through the door from the kitchen into that room? Answer, we didn't think we had time to be waiting and looking and stuff. I was just running as fast as I could, and so was my brother. And he got there first, and we just went right through the doors. And as soon as I saw something, I started firing. It was no time to just be watching and trying to see where they were exactly, and so on. And
that doesn't sound very much like lying in wait to me. That does sound a lot more like bursting in to do the act.
Eric Menendez was questioned along the same lines and gave the same answers. So there is a complete failure of proof in this case to show that there is a substantial period of watchful waiting. The prosecution may direct you to evidence of the statement that Lyle Menendez gave Detective Zoller on September 17th, where he said that my parents sometimes were in the habit of falling asleep. That evidence is contradicted by the maid that they didn't fall asleep in front of the TV. But in any event, that would go to the issue of whether they were taken by surprise. It would not explain the absence of proof on the period of watchful waiting. There is no evidence anywhere other than what I've just indicated to you, which shows that this was a crime, if it was a crime, where someone was watching and waiting for a substantial period of time in order to act. And so there is a complete lack of evidence as to the most serious allegation that was made in this case, which is a special circumstance allegation.
Well, that I understood. That made a lot of sense.
I hope I haven't bored you to death with the law, because as I said at the beginning, the law in this case is the second most important thing that you as jurors have to work with in deciding whether the charges are true or not, whether they have been proven beyond a reasonable doubt. And I realize trying to teach you this at 3 o'clock in the afternoon is probably very difficult. You've been an incredibly patient group of people, and patient through all sorts of abusive waits that unfortunately take place when there are so many people involved. I, on behalf of Lyle Menendez, would like to thank you, because I'm not going to otherwise get a chance to talk to you again. And we appreciate your time and your attention. I sincerely believe that you will reach the correct verdicts in this case. And I have no doubt that you will conscientiously weigh and consider the charges and find, after consideration, that Lyle Menendez is not guilty of the charges that have been leveled against him by the prosecution. Thank you.
All right, thank you. And we'll resume tomorrow at 9 o'clock.
All right, that's their scheduling at this point. So that was the argument. I will say it started off stronger than it ended, in my opinion, as is often the case. By the time you're 2 hours in, your ability to wing it on the fly can be a little bit challenged. But by and large, a lot of stuff here that I saw that I liked, and a lot of that did carry through the whole argument. Very much a let me make this simple for you kind of approach, and just across so many different levels of how he presented the argument. The visuals, okay? The visuals are great. I'm going to be able to picture the stair step in my mind, the little mountain guy. I'm going to be able to picture that extremely easily and remember, oh yeah, reasonable doubts all the way up here, beyond a reasonable doubts all the way up here. I got to have a really strong feeling. I got to have that abiding conviction. I'm going to be able to visualize, at least generally, like there was a decision tree that I have to go down with the murder charge, where I have to be like, is it murder first off? And no, and then if it is, what kind? And then, like I'm going to remember how he broke that down for how to decide the case generally. And then I'm going to remember the very specific things he told me about, although we kind of started losing that towards the end with him. Like, I'm not sure why it matters that Jose was shot in the back of the arm. But certainly the stuff that went to the state of mind, premeditation, and those types of things, pointing out testimony about the abuse from the doctor and the role of fear and how fear affects the thinking and processing, the characteristics of the crime scene. Definitely going to remember that Dr. Oziel was a problem. I shouldn't pay attention to anything Dr. Oziel said. What a freak. That guy was a mess. And then it may or may not matter what position anybody was in at the time of the shooting. But the big takeaway is that even kind of in the morass of dealing with the special circumstances, very end of the decision tree, he's still doing that, making it simple. Let's read the thing, because you're probably going to have to not be accused of like being misleading about the instructions or whatever. But then I'm just going to summarize it for you and break it down. There's two things here. There's one thing here. It just reflects this very, very organized and systematic type of thinking about a case. And I think that's going to be very helpful. It usually is, just being able to keep things organized and clear and simplify and everything like that. But particularly in a case where, there might be a variety of disputes about different things. There's going to be a lot of issues, we already know, dealing with scientific evidence. And a lot of that stuff is going to be crazy complex. And so if he's got the ability to kind of take what he just did for that jury and give it to the judge in terms of break it down, here's what you have to find for this to be good science. Here's three elements, so to speak, three factors I think it's four in Daubert, but anyway, that you have to consider. And then, work through that. If he's able to bring that ability to like highly technical evidence that they're likely to get, about probabilistic genotyping, the judge will appreciate that. Really, everybody will appreciate that. Maybe this particular judge has a degree in biology. It wouldn't be that big of a deal. As you go up the chain on the appeal for your record and who you're preparing this record before, for, the more likely you're going to run into the lawyers who became lawyers because they were bad at math and science. And so they need it to be really, really simple. If he's able to do this kind of breaking it down, organizing, give you visuals and so forth, it's going to be a huge asset for the team. A lot of just sort of subjective, like immeasurable things. I get a very sincere vibe from the guy. This is going to be, personal. There might be, differences about it, but he just presents very differently, in my view, from many other defense lawyers. Not always, doesn't always mean that you're unsuccessful if you aren't necessarily coming across as the most authentic, but it is a thing that I think people notice, even if just subconsciously, and they're not like consciously aware of like, oh, I really, believe this guy. He seems legitimate. Seems to really believe the words that are coming out of his mouth. You're still kind of evaluating that on some level anytime you interact with somebody. So I think that's a benefit to have, because it makes you come across as trustworthy. And even if they don't believe you, they aren't necessarily suspicious of you. People that are suspicious of you are looking for reasons to disagree with you. And you don't want that as a defense lawyer. You got enough disadvantages already sitting there with the state and the police and all the quote unquote good guys sitting at the other table. You don't need any more reason for the jury to be looking to find to find you sus. So he has some like facial expressions, eyes up a lot, and some just some kind of personal expression when he's expressing certain ideas. The flow is just so natural. I mean, the guy can talk and talk and talk. I mean, it's a lawyer for a reason. But he's able to, keep that organization reasonably well without his notes. At least not like super heavy dependence on them or anything like that. There were points where it seemed like he had to kind of go back and like flip through and check and see where he was, but comfortable with that, comfortable with the pauses to do that. Not gonna like babble nervously just to fill the dead space while he's trying to find where he was in his outline. Just go ahead and sit quietly. Seems very comfortable. And so remember, by the time he's giving this closing argument in the case, he's been the lead, like the top guy in the San Francisco Public Defender's Office for over 20 years at this point. He's been like, long term. This is like halfway through his career. Okay. He's had another 30 some years since then. And so you kind of expect, well, kind of like anything in life, unfortunately, time is not really our friend, and your skills fade. They do. Your skills fade over time with age. You're not going to be as sharp as you were in your prime. I think just given kind of what the skill set is to be a lawyer, you probably have a much larger window of being in your prime. But as you get old, you just, things happen beyond your control. You lose energy. You don't sleep as well. You start to lose a little bit of cognitive function. I can't expect him to be the same guy 50 years into his legal career as he was, back at this point in time. But nevertheless, I expect a lot of this stuff to carry over because it just seems to be kind of part of who he is. And I think by and large, those things are going to be helpful. And so when you take that and you pile that on top of This is a guy who has spent almost 50 years, almost half a freaking century as a public defender. Well, we're back in the same boat like with Mr. Novak now. You don't do that because you're like, "Ooh, I'm going to be super rich. I'm going to fly around on private jets and have a very prestigious career." No, like you're shat on for most of your work. Nobody likes you. You don't get paid well. You get blamed every time anything goes wrong in the process. It's like such a low reward job. So they do it because they believe in it. That's who Tyler Robinson has on his team. And I think it's so important to emphasize that, because I just, it's a different mindset. I don't know how else to explain it, but public defenders are they're not like other people. They're not like other lawyers. It's probably the place where you're most likely to find people who are doing the work out of a sense of principle, because they really believe in it. They put up with so much shit in order to defend those principles. And I don't even just mean the stuff I was talking about, like, the external stuff, the caseload stuff, the, fact that ineffective assistance is like the go-to way. If we're going to have to reverse something, we're going to find a way to make it, ineffective, so we can blame the defense lawyer for it. The shit flowing downhill kind of stuff. The people hating you, how do you defend those people? Like, I'm not even talking about those things. I'm talking about like actually working with somebody like Richard Ramirez, who can't do his interview with your psych expert without trying to jack off. Like, you deal with so much shit in the job and terrible people. Okay. These guys have dealt with terrible people, the worst people on the planet. These guys have sat next to in court because they wanted to. Not because they wanted to. They chose to do that, to sit next to the people that nobody else on the planet wants to sit next to, and say, you're going to have to go through me to get to this person. You're going to have to play by the rules. You're going to have to play fair. You're going to have to win fair and square. It takes a different person to do that. He's got 2 of those on his team. Okay, so this is why, big reason why I am very, very skeptical of any kind of claim or argument or insinuation that, oh, these guys, they're not really on Tyler's side. They're not acting in his best interests. Bullshit. These guys are going to put Tyler Robinson first, even in situations where he maybe wouldn't, because that's what public defenders do. They're like, no, you're gonna be making a really bad decision here. We've got a good way to handle this, good aspect for that. Like, they want to get the best result they can for him. That's who these guys are. So no, I'm gonna require a lot more than just some things are happening in the case that I don't understand as an explanation, as proof that somehow Tyler Robinson's defense team is against him, is not on his side, is not acting in his interests. Gonna be very difficult for me to believe that. Speaking of which, I see we had Project Constitution in the chat. Michael Burt needs to recuse himself. He is the cousin of Terrell Farnsworth, a key witness in the case. That is a huge conflict of interest. Well, let's chat about this, shall we? Because first off, I've heard so many different relations that Mr. Burt supposedly is to Terrell Farnsworth that it calls into question whether he is in fact any of them. For me, if you don't know if he's like the brother-in-law or the cousin or the something, then that seems to have a kind of big gap in the family tree here. Okay, so I I do not accept the proposition that there is a relationship here. It has not been established to my satisfaction. But let's say there is, hypothetically, he's the cousin. Well, guess what? That's not going to be a disqualifiable conflict of interest. And how do we know that? Because we can look at the rules. Okay, so let's just go ahead and pull up Utah's Rule 3-1.7 conflict of interest rules. So the rule itself, what we're dealing with is this one right here, A2. So you're not supposed to represent a client if there's a conflict of interest, concurrent conflict. And that exists if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Personal interest in your family relationships and so forth might get you in a position to where you would not be, so inclined maybe to do a good job for your client. That's a conflict of interest. But see, you get into the comments. This is where the meat is in all of these rules. It's always in the comments. And we get to the personal interest comments. And so, lawyers are closely related by blood or marriage. Closely related by blood or by marriage. There may be a significant risk that there will be problems. And so each client is entitled to know of the existence and the implications of the relationship between the lawyers before the lawyer agrees to undertake the representation. That a lawyer, and this is just specifically dealing with a lawyer related to another lawyer, but it's going to be the same thing with if you're talking about a lawyer related to the opposing lawyer, the opposing side's witness. Okay, we'll grant this would apply to a opposing side's witness. Client's entitled to know of the relationship before the lawyer agrees to undertake the representation. Thus, a lawyer related to another lawyer, e.g., for example here, this is what a close relationship is: parent, child, sibling, or spouse. Ordinarily may not represent a client in a matter where that lawyer is representing another party unless each client gives informed consent. So yeah, a lot going on here. Number one, it's not a close enough relationship to create a per se conflict of interest. Everybody on the planet, every human being on the planet is a cousin to some degree. Just depends on how many generations you go back and I guess where you set the line between modern humans and human precursors and so forth. Cousin is not close enough. The whole reason they have these rules anyway is because they're based on the nature of the relationship and the closeness of the relationship. You better be close with your spouse. You better know a lot of things about each other that the rest of the world doesn't know. You better have a lot of loyalty to that person. But there's a lot of cousins that have never even met. They just know each other, that they exist. Have no relationship, no loyalty, no closeness. Cousin is not a close relationship under Utah rule or under any rule that I'm aware of, because there's like federal ethics rules and things like that. Doesn't apply. Cousin is not going to be a disqualifying one. And even if it was, it's waivable. And you would never know if it's been waived because you don't have to do that as a matter of record. You don't file. You don't have to file that. It's just something that is done that is kind of kept behind the scenes. So I reject this argument thoroughly. Of course, he doesn't have to recuse himself. If this was an issue, he wouldn't have come on board in the first place. Also got a note, once again, easy to forget this whole legal system is an adversarial process. You have two sides that want to win. And the reason why it's set up that way is so that each of them is incentivized to bring their best case and to get themselves in the best position. And so this theory here has been floating around for a long time. Okay. Not the first time I've seen it. It's been floating out around there for a long time. And who's not mentioning it? Yeah. Once again, apparently the internet has figured out all kinds of stuff that the participants in the case have not said anything about. Who has an incentive to keep this trial clean? The prosecution. You think they want to do this again over something stupid and preventable? Yeah, they don't want to do it again. It doesn't work to anybody's advantage. So appreciate the super chat, but this one is, I think, way off base. And quite frankly, given who Mr. Burt is and where he comes from, you'd be stupid not to want him on your team if he is willing to serve on your team. Would absolutely waive this conflict over a cousin, please. I started this one because this is an interesting legal question. If your lawyer can, I think this means admits. If your lawyer admits to you committing the killing, could that be an issue later on for some sort of ineffective assistance of counsel or other argument? I love questions about attorney decision making. The who gets to decide what as between the attorney and the client. You would think it would be really crystal clear. It is not necessarily. And the reason why is because the general division of authority is that the client decides the objectives of the representation and the lawyer decides the strategies, the methods. And so taking this example, you could be like, look, the only possible strategy for me to get you any benefit in your case is if we concede that you're guilty and then argue sentencing or argue mitigation or argue, self-defense, some kind of affirmative defense. But to do that, you have to admit the underlying act. Strategically, it's the only option I can see. It kind of makes sense that would fit into the strategy category, but it doesn't, because whether or not you are innocent or guilty is like the core of the objective that the defense gets to, the defendant gets to decide, because he's the one that's got to live with the consequences. And so as it turns out, there was in fact a U.S. Supreme Court case on this, not even that long ago, from 2018, McCoy versus Louisiana here. And this was exactly that case. It was a death penalty case. The lawyers decided we can't win on guilt. We have to just focus on mitigation. And the defendant didn't agree with that, and they did it anyway. And so this was overturned. They don't put it in the framework of ineffective assistance of counsel because it's not a question of like, did you perform well as a lawyer? It's a question about the structure of this relationship itself, and did it fall apart? So basically they said this was it's a structural error. It's not even like ineffective assistance. It's a structural error. So bad you don't have to show prejudice. You don't have to show, oh, he probably would have won if he had, litigated his guilt instead of conceding it. Flat out, he gets to decide if he's going to agree that he did it or not. So no, to answer the question, I mean, the lawyer doesn't get to do that. So we can infer, even though like McCoy is 2018 and we just watched this closing argument from 1993, they didn't have that decision at the time. What if, but we can infer that in this particular case, the Menendez brothers were on board with that decision because they testified. They got on the stand and volunteered. They assisted with the presentation of that case, admitted they did it. The argument went to, the mental states and the reasons why and so forth. So that was a really good question. I love when I see like questions fly through the chat. I'm like, oh, I got to jump on that one. So thank you for that. Ginger Puff 764. Hi, Andrea. I'm late. What's happening? Something going on in Tyler's case? How did I miss this? Have to catch up. Ginger Puff, sorry to catch you by surprise. This is absolutely not new at all. We are watching a closing argument from 1993. So it's 33-year-old news. But the reason why we're watching it now is because it's to get a little bit more insight into Michael Burt, Tyler's attorney, because he was one of Lyle Menendez's attorneys in the first trial. He gave part of the closing argument, and I just thought it would be. I did a Substack on Richard Novak and his background and why I'm impressed with him as a criminal defense lawyer. And I wanted to do a little bit of the same for Mr. Burt. And we happen to have this video, it's there. One of the early court TV televised trials, that first Menendez trial. So we had the argument available to watch. I thought it would be fun to watch. We're having a windy day here at my place. And so I just decided to go live randomly. Didn't mean to jump scare you into thinking like there's been a big major development or anything like that, because there has not. It's really nothing new, but a little deep dive, if you will, into some of the personalities that we're going to see in the case. Good Dude 8767. What is your opinion on the strength of the case against Robinson? Is there any chance he walks free? So there is always a chance he walks free, in part because anything can happen at trial. I mean, things can happen. Things can go very, very sideways in unpredictable and unanticipated ways. So there is always a chance he walks free. We, of course, don't know that much about the strength of the case at this point. We just have the bare bones outline from the probable cause affidavit and how the state has presented it. And so we already know there might be some kind of asterisks in there when it comes to strength and quality of the evidence. And the example being, they mention in the PC affidavit that they recovered DNA that's consistent with Tyler. And it turns out, yeah, that may be true, but it may be a little bit more of a complicated question than that, because if, as the defense seemed to be saying, the DNA samples are all mixtures and they're all these complex mixtures, 5 people or more is an extremely complex DNA mixture, there might be a little asterisk on that DNA link and the strength of it. And we're not necessarily going to know about details like that. We only know that one because the defense kind of chose to tell us in the hearing out of sort of nowhere on the disqualification motion. You just kind of volunteer this fact. By the way, had the investigator on the stand. Did you know that the DNA was a mixture of 5 people? And so there could be other things like that in there as well that we just don't know the details about. We will know much, much, much more after the preliminary hearing. What I will say at this point is this, is that as a lawyer, you get real good, real fast at reading the probable cause and kind of getting a sense right off the bat of how much do I have to work with in this case? And that's because a lot of what you find in the probable cause affidavit is going to tell you, okay, there's a lot of corroboration here. There's very little corroboration here. There is potential suppression issues here. There's like process problems that I can spot through this investigation and this scenario. So that means I'm going to have things to litigate. That's a better case than ones where there's not. My read through Tyler Robinson's probable cause affidavit is that, yeah, factually, if the state has what they say they have, it's going to be an uphill battle. If they're going to be able to present it in the way they've presented it, like they did in the probable cause affidavit, it's going to be an uphill battle because there is a lot of layers of corroboration here. And that's the problem for the defense. Okay, maybe I can poke a hole in the DNA. But if everybody on the planet can recognize Tyler Robinson on the surveillance footage, and somebody can identify the rifle as his grandpa's, do we need the DNA? Like you can reach the inferential connection between what's this guy doing 4 hours away from home on the campus of UVU while he's sending the text messages and so on and so forth. This is a difficult case for the defense because there are so many layers. Means they have to blow holes in pretty much all of it. And if they aren't able to do that, then what is left is still able to corroborate. If they can't, if they get rid of the DNA, fine, but they still got confessions, they still got video, they're going to have location data. We know all that. So to me, as the defense lawyer looking at this, I'm not looking at this case, my initial gut impression. Okay, when I get the probable cause affidavit, and you evaluate, you do at least some evaluation right off the fly, and that's because you got to be prepared for your client and what might happen. In some cases, it gets complicated. Like in my state, you only actually have the right to plead guilty to the charge at your arraignment. If you don't plead guilty at your arraignment, you don't necessarily have the right to plead guilty later on. You might be allowed to, and there's plea agreements and stuff, and you might do that. But you only have the right that can't be taken away from you to plead guilty to the crime that you are charged with at your arraignment. And the reason why that can matter a lot is because of double jeopardy implications. If you've maybe undercharged me and you're going to be able to nail me with something later on, I might be real inclined to plead guilty at arraignment so that you can't amend it to something much, much more seriously, give you a couple weeks and you figured that out. So you do got to be kind of quick at spotting stuff. And it doesn't mean that that's your final decision or anything like that, but it just, is your overall impression. Is this an easy case to work with? Do I have a lot to work with? Do I have little to work with? And this probable cause affidavit does not give the defense an awful lot to work with in the case. So that's my best answer to that. We're going to have to wait and see is really the bottom line. He Who Remains 2025. Candace Owens has claimed that the FBI is withholding evidence. Is this true? Is there evidence of foul play by the FBI? So the defense has complained that the FBI did not turn over the files, like the data files for their DNA analysis and just their DNA analysis. It was the ATF that did DNA and firearm. No, the FBI did firearm too. Yeah, they both did. I think they both did one of each. Anyway, getting the feds to turn over their information is always a nightmare in a state prosecution. This has come up in a lot of the cases that we've looked at. Karen Reed case, we learned all about Tui. Tui came up in Koberger. Tui came up in Karen Reed. Anytime federal investigators are involved in a state prosecution, you are likely to encounter the word Tui. It's spelled Touhy. It's based on a decision that says that state courts don't have legal authority over federal law enforcement, federal officials. Under the supremacy clause of the U.S. Constitution, federal government is the supreme law of the land. State doesn't have jurisdiction to order a federal officer to do anything. And so that means that the normal tools you have to get discovery are pretty constrained. You can't just go to court and say, court, order them to do it, because they're not subject to that order. You can't just send them a subpoena to say, send me what you have. They don't have to respect your state subpoena. So there is already always a big hassle that comes with having federal investigators involved in a state case. That in and of itself is perfectly normal. The stuff that the defense has been asking for also does appear to be, in many respects, beyond the norm of what you ordinarily request. And so there's just kind of conventions that are pretty typical. Not every case is going to have DNA experts, for the defense who are going to come in to, look at the electropherograms and look at the, settings and things like that and reevaluate the testing. So you don't necessarily always need all of that underlying information. So it's very, very common to just produce the report, kind of the bottom line, the sort of bare minimum stuff. Here's the test that we did. The tests follow normal standards and protocols that are typically, available. You can get them online, or they can produce those sometimes as well, and have done in this case. But the actual like digital file of what your DNA analysis program produced, most cases you aren't going to need that. So a lot of that stuff not necessarily automatically disclosed. Maybe it should be, but then you run into the opposite problem of the discovery dump, where there's so much stuff here and you're dumping so much of it on me that I don't have time to go through all of it and make sense of what matters and what doesn't. Like, there's no perfect solution when it comes to discovery. Over disclosure is not necessarily better than under disclosure. So that's kind of the background of how all of this stuff works in the first place. And yeah, the defense is asking for a lot of stuff that is also just above and beyond things like the data files and stuff. Like they want the source code for strmix. The program strmix is a probabilistic genotyping software, meaning it does extremely complicated math calculations about the likelihood of different combinations of alleles. It was developed by the Australian government in concert with somebody else. But so, and it's, now it's been licensed out and people can buy it and stuff. It's a proprietary software. Now, a lot of legitimate reasons to not like stuff that's being used in court, being behind a proprietary kind of shield. But nevertheless, like asking for the source code for the proprietary software, this is a big ask. Okay, they might get it, they might not, but it's definitely like not a normal everyday thing to ask. And there's absolutely going to be fighting about it if it does. And if it does get produced, it's almost certainly going to be like under a strict protective order and stuff like that. That's our context. So the FBI withholding evidence, what we know so far, based on the last hearing, is that the FBI did produce their DNA data. And so I think at this point, they are still waiting on data for FBI firearm analysis, which I think was the tool mark analysis. There was just a filing on it, and I don't remember it off the top of my head. Maybe I can find it real quick. I don't know. Let's see. Let's see how well I have my own little archive organized at this point. Yeah, I'm not sure now off the top of my head where it was. Yeah, so maybe it was supportive continuing the preliminary hearing. No, anyway. They made some comment about it recently. Anyway, so what was at issue was the raw files from both the ATF and the FBI for DNA analysis and test and analysis they did on the firearm evidence. They have gotten, my understanding from the last hearing, everything from the ATF, and they've gotten the DNA now from the FBI. So they are still awaiting some underlying documentation that relates to the FBI's tool mark analysis. the one that was inconclusive. So that's kind of our factual situation right now. Is that evidence of foul play? Not in the way that's like unusual or different, in my view, from just how the FBI ordinarily plays. They're a massive bureaucracy. They don't have to answer to the states, and so they don't. It's extremely complicated. It's obnoxious dealing with them. It takes forever, and that's all normal. It sucks, but it's all extremely normal. So I haven't seen anything that's like, oh, this is, particularly egregious. And one of the biggest tells that there isn't anything egregious really happening here. Once again, guys, remember, we're in an adversarial system. Parties have their incentives to act to their own advantage. We have not seen a defense motion to compel. Now, remember, you guys are sharp. I just said, but the judge, that's the state court judge, he can't compel the FBI to do anything. That is correct. But he can compel the prosecutor to do stuff. And if the prosecutor isn't able to produce it, he can sanction the prosecutor for not producing it. He can exclude it from the prosecutor being able to use it at trial. He can require, an adverse inference instruction be given to the jury that, hey, the prosecutor didn't produce this. He can put that ball in the prosecutor's court to get on the phone to the FBI, be like, you need to get me this shit right away. Because when it comes to giving their stuff to the prosecution, a little bit of different rules apply than comes to giving it to the defense. So, we haven't seen a motion to compel. Nothing. There has been one motion to compel that's filed by the defense, and it has nothing to do with general discovery, nothing to do with the FBI. It has to do with they want the internal communications that the prosecutor's office had about Chris Ballard's press release when he made statements to multiple outlets about what the meaning of an inconclusive test result is. The fact that it did not, in fact, prove Tyler Robinson's gun did not shoot the bullet fragment. It just couldn't conclude one way or the other. They want those communications. That's the only thing they have filed a motion to compel about. So the defense is not asserting any kind of foul play, and there are very much remedies in court for that type of thing. So to me, that is significant because they're the ones with the incentive to ask, and so the fact that they haven't asked, if they're not worried, why would I be in a better position to be worried than the defense team? I don't think it's an extreme position to consider the experts on the defense to be the defense. To Truth for Liberty, do you find the FBI PC affidavit a little strange? It seems to swear as true that the affiant obtained information, not that the information is actually true. I think the reason why is because the Utah rules and many rules in this particular context, when you're just dealing with an affidavit like this, they allow them to rely on hearsay from other officers. And so it wouldn't technically be true for him to say, I obtained this information, if he's not the one who went and did the interview or whatever. He's relating the details of the investigation from other officers. So we can pull that up. Let me get that one real quick. Here's the probable cause affidavit. Let me get it shared here. Okay, can we see that? I believe there's probable cause to charge the defendant, and the following information was obtained by your affiant from police officers, multiple video recordings posted on social media websites, UVU, campus surveillance cameras, and those who witnessed the incident. So those are his sources. Here's the information that he's providing, saying his investigation generated this information. And by submitting this affidavit, I declare under criminal penalty of the state of Utah that the foregoing is true and correct. Formal wise, it seems perfectly adequate to me. It is a sworn statement. He is disclosing the sources of his information. The fact that he doesn't have personal knowledge is going to be allowed in this particular context. But so he's swearing under penalty of perjury that he got this information. And that is also, like, to your point, he's not saying it's actually true. That's for the jury to decide. I mean, he is able to present, here's what I think I'm going to be able to prove. But for purposes of probable cause, it's just what information do you have? Whether it's believed or not, whether it's good information or not. That's for later determination. They don't even consider that at the preliminary hearing, right? All we've heard about the standards for the preliminary hearing is they don't weigh evidence, conflicting evidence. They just assume it's in the state's favor, don't consider credibility, etc. They're not considering whether the information is true. They're just considering, did they have this information? And the reason why that's the case is, so, I mean, the main reason is because police can rely on bad information. It does happen. I don't like it when it happens, definitely, but it does. Sometimes they might exploit that, like in a certain, I don't know, Afro Man case where they get this patently ridiculous, absolutely insane story from a CI that they decided to lean on, you know, somebody that they're going to arrest for drugs. And they're like, why won't you, tell us what you know about Afro Man so that she doesn't catch her own charge. And then don't ask too many questions about what they get. That can be exploited, definitely. And that's a real problem. I don't like it at all. But it also just happens that sometimes there's innocent misinformation. People really do misremember things. Super, super common. And your probable cause, it might be based at least in part on eyewitness testimony. And your eyewitness could be off about something. Other details, they could be off for any variety of reasons. And so it's not going to defeat probable cause if the information is bad. But unless they knew it was bad, but that's a Franks issue. That's Delaware versus Franks. That's including false information in your affidavit. That's a different problem. We would definitely hear from the defense if there's a Franks problem in the case. But otherwise, just for general purposes, it's based on the information they have, and whether it's good or bad, that's later on for the jury to decide. That's the whole point of having a trial. It's like the nature of the distinction between those particular phases. So in that sense, no, I don't personally find the affidavit to be strange. It seems to me to be pretty normal and legally adequate. So that's where we're at. So yes, I think you shop. You know who else? You know who else is sharp? You know who else is sharp right now? Phillies are sharp right now. I don't want to jinx them. As soon as I say it, we'll go back to being like 10 games below 500 or whatever it was. But yeah, we do have a game to watch this afternoon. Very exciting. That's probably what I'll turn to, since it looks like our wind has not died down at all. It is simply not going to be the kind of day that enables me to go productively spend it in the outdoors. But that's okay. It happens. You have 50 plus cousins, some I've never met. I have cousins I've never met. I have an uncle I've never met. I know he exists, but he moved across the country. I think maybe even before I was born. Never met. I don't even know if he has kids. I don't know if I've got cousins over there. I don't even know. This is America. If there's one place, okay, I will say this. If there's one place where everybody is going to know who their cousins are, it's probably Utah, because of the Mormon genealogy thing. But again, knowing they exist doesn't mean you have a close relationship at all. Harbinger of imminent death. It is common to see judges consider new charges when considering a bail revocation. How is this compatible with the presumption of innocence? Well, I raise that question a lot, quite frequently, because yes, the fact that somebody has been charged with a new crime is not proof that they violated the law. It is an allegation that they violated the law, and so sometimes, it might come down to how is the bail order worded. See, they figured this stuff out. They figure out the workarounds. And so what they'll do in this situation is they'll just write the bail order so that the problem isn't a violation of the law. The problem is there being probable cause to believe you violated the law, or there just simply being a new accusation supported by probable cause, something like that, so that it's not, your release status isn't hanging on whether or not you actually did commit the new crime or not. Because if that's the issue, I've got a very good argument. We can't do anything at all until you go through trial on that new charge. And then we know one way or the other whether you violated the law or not. Many judges will be amenable to that argument, some will not. There are lots of prosecutors in black robes out there on benches around the country who will not be receptive to this argument. They will think that the accusation and the filing of the probable cause is enough to establish the violation of the law and revoke somebody's release. And then what do you do? What do you do? Is it a case where it's worth it for you to hit the brakes on the case and go and try to get interlocutory appeal or a writ of mandamus or something like that from some higher court, higher authority? Tell your judge you can't do that. Put everything on hold to fix that situation, which may not even be successful, by the way, because if you got to go through discretionary review, you almost never are. Probably not going to meet the standard. Standard requires that there be, generally speaking, for discretionary review, that the legal issue just be clearly established. That it's not a gray area. It's not one where there's room for disagreement, stuff like that. And so if there is no actual case where somebody has done this before to take it up, and the court has said yes, if the condition is a violation of the law, then you are going to have to wait until that person has gone through trial. And then we'll know, and then you can deal with your release order. You don't have that crystal clear law, then you probably don't have a basis for discretionary review. Hi, sweetie. A little visit from Miss Corona here. So strategically, do you do that? Do you spend the time to do that while, by the way, your client is sitting in jail? Or do you do what is going to happen in probably, 90 to 99% of cases that are not, serious felonies where you're looking at death or life in prison or something like that? They're gonna plead out because it's faster. It's faster to just take the guilty plea, whether you're guilty or not, because the time you are going to spend sitting and contesting this and then going through trial and so forth is longer than the time you'll sit there if you just say, fine, I'll take your stupid plea deal. That's what happens a lot of the time. Not very compatible with the presumption of innocence in that situation. So yeah, this is just one of the legal realism aspects of the practice that I can sit here with my positivist self all day and appreciate what the rules say. But at the end of the day, what matters is what the judge does. And my understanding what the rules are and where they come from and whether they're valid and so forth is helpful to the extent that it allows me to predict what the judge is going to do. But that's assuming the judge is going to follow the law. And that simply doesn't always happen. Oh, there was Andrew Fleischman. I don't know if any of you guys follow Andrew Fleischman over on X. He just had a story yesterday. I'm like, God, I might be interested in looking at this and like maybe doing a read through of this transcript or whatever, because he had a court hearing where there's like clear free speech issues that the judge just is not getting it, and like to a non-comprehension level that is astonishing for some, anybody who's gone through law school, let alone somebody that's on a bench somewhere. And unfortunately, yeah, that kind of thing happens. The judge doesn't know the law. Worst case scenario, the judge doesn't care about the law. Those are really unpleasant situations. But the reality is you learn how to navigate with that judge in the way that is going to serve your clients the best. If pissing off the judge by enforcing the letter of the law is going to make a worse situation for your client, then you don't do that. And that's just the practical reality of trial work and what it's like in the trenches. Oh, Jeff went ahead and posted the post. Thank you for finding that and doing that. Like, it's crazy. Crazy the way judges behave sometimes. So guys, hey, thanks for joining me for this little impromptu. It wasn't the most riveting closing argument, but gave me a sense of the guy. I do think he is a little on the nerdy side, and that's okay. Far be it from me to take issue with nerdy. But I think that helps me appreciate a little bit too, kind of where they're at with the division of labor. And they had identified, Mr. Burt identified as he was kind of taking the lead on the expert stuff, evaluating what they had and do they need experts, and this issue with the discovery that we talked about, what do they need, and things like that. That is highly technical stuff that does require very systematic, organized thinking. It requires a lot of experience to know what you're dealing with. You got to know what you don't know in a lot of these situations. And you may not know, for example, that this whole issue with the testing of the seems to be comparative bullet lead analysis, but like just really not clear from what we have in the record so far exactly what the FBI is trying to do with the bullet. But they want to do more testing on the bullet and some type of chemical testing. And if you have not been a lawyer for a long time, you might not know that there's issues around that and kind of how they can do it, how they can't do it, what the history is, and so forth, because it hasn't been widely used. Definitely hasn't been used in court since like the early 2000s. So if you didn't know that and you just see this come up, you might just kind of take it for granted. Oh yeah, okay, they're going to do this thing, and then I'll get a report and I'll see what it, if you don't already, if you haven't already been around to know, then that might be an issue that you wouldn't spot right off the bat. So the guy with the most experience, with the organized mind, the systematic ability to break things down, skills that are going to be extremely critical when it comes to these technical challenges that we know are coming, because explaining probabilistic genotyping to somebody that's not a science person or a math person is going to be really difficult. And so you need, that's going to be a very important skill set to bring to that particular task if you're trying to convince the judge why this thing that the prosecution is trying to do with this software that, like, hey, it's used all over the place and everybody does it, and so what's the problem? Well, explaining the problem is going to get real complicated. But also, just I like the guy. I like him. I watched him. I like how he lawyers. Sure, he's not perfect. Nobody's perfect. There's always going to be lulls in the closing, and there's going to be parts where maybe you could have said it. You could have said it better. There's going to be parts where maybe you got a little distracted and off script. It happens. It's totally fine. But at the end of the day, I came away from it like, oh, I like this guy. I trust this guy. This guy seems sincere. I don't feel like he's going to bullshit me. He's definitely not emotional. I mean, if anything, anything to criticize. It's like the whole modulation and cadence and everything was super flat. There wasn't a lot of variation to like let me know, oh, we're excited now, you know, or like, you can go ahead and doze off during this part because we're just going to be reading some case law. So not a whole lot of variation in his presentation, but that said, to the extent it's kind of flat, it's flat in a I think a fairly good way, like just an academic way, you know, when he was keeping things tight at the beginning and breaking down, like, here's the visual, and now I'm going to just like carefully pepper in the facts here to let you know what it is we're talking about and why it matters. I found it all extremely easy to follow. And even if it's kind of flat, wasn't boring, wasn't putting me to sleep. It was only when I kind of lost track of where they were going with the argument that it's like, okay, now we're in a drone, and that's not good for anybody in the middle of the afternoon. It's never a bad thing to have a likable lawyer, you know, somebody that people are going to trust. We're going to look at Kathy, guys, at some point, just by way of a counterpoint. I'm going to bring that up because I know a lot of people have the impression of Kathy from the Corey Richins case. And in fairness, I do need to watch that to get a sense of like why the strong reaction against Kathy. But I do want to highlight as well, like she is no slouch. Okay. When I praise Mr. Novak and Mr. Burt particularly highly, it's because they really are extraordinarily qualified. These guys are the creme de la creme in capital representation. Kathy doesn't rise to that level, but that doesn't mean she's a slouch. She ran a federal public defender's office for a long time. Okay, she has also been around the block. She's done a lot. So we'll talk about Kathy at some point, but I have to make myself watch some of the Corey Richins first, so I can really get the flavor, get a sense of what to share and stuff like that. But yeah, I'll get it done. If we get more windy days, then I'll have the time to kill anyway. So not like straight out dissing Kathy, but she's not on their level. But not very many people are. Very, very few defense lawyers in this country are on the level of a Richard Novak and a Michael Burt. Harbinger of imminent death. Allegedly, some agencies like to schedule arrests to maximize the time between arrests and arraignment, so the defendant sits in jail longer and feels more pressure to accept a deal. Have seen this. So I mean, there can be strategy involved. The common one is the 72-hour hold, which is basically when they arrest you just on probable cause, you generally have to be brought into court for a preliminary determination that there is in fact some basis to hold you. There's sufficient probable cause to hold you. And that's commonly the 72-hour period. And so, but it you know, they don't have court over the weekend. And so they figured out, like, you know, oh, if we arrest you on Thursday afternoon or Wednesday afternoon, you know, exclude the weekends, then that's the law, you know, then we can make you sit there until Monday before you get a chance to go into court. And if we have all that time, you know, we can do all kinds of nefarious things in the meantime. Haven't seen it so much with arraignment, mainly just because, at least in superior court, when you're dealing with felony charges and stuff, arraignment is often like not really one of the earliest parts of the process. You'll typically have probable cause and release considered a lot sooner than you're going to consider arraignment. And for most people, the issue is being held in jail. Like, that's the primary concern. If I think I'm going to be able to get out of jail fast, that's what's going to put the pressure on me versus, you know, it's not clear to me if I'm going to be sitting here or not. So pushing back the arraignment in and of itself isn't necessarily going to be particularly effective, because if I'm stuck in jail anyway, if I've already gone to court and I've got an order of detention, then I'm going to be sitting here, regardless, and it's just going to be the same kind of calculation I'm going to have in any case where I'm held pre-trial of, is it, does it make more sense for me to just plead versus getting out? But if I'm arrested at 7:00 p.m. on Sunday and I only have to spend one night in jail and then the judge cuts me loose, that's going to be a different situation. If I have to sit there 5 days before I even know if the judge is going to cut me loose, I might be more in a hurry to cooperate. So yeah, I mean, I think things like that happen. Absolutely. Sometimes it's strategic. Most of the time it's not. Most of the time it's just bad luck. You happen to get arrested on Wednesday afternoon and, shouldn't have driven drunk, or whatever. But sometimes, like when it's an arrest on a warrant or something like that, when they're doing, a good one is when they're doing probation, like probation searches or probation reviews or things like that. Pick the afternoon where, if we get the guy, if we find some kind of violation and we take him in, he's going to sit there. He's going to sit there the longest before the judge comes in. And that works particularly well if it's like, a probationer that we're trying to flip, we're trying to get information from them or stuff like that. Yeah. Those things happen. Absolutely. So I buy that. She served on the National Steering Committee for the Clemency Project. Yeah. Mississippi Trial Lawyer of the Year. She's impressive, guys. I'm telling you, like, Kathy isn't a slouch. I just realized she's off-putting, I think mostly from a tone standpoint. And I understand that already, because even just in the tiny bit she did in Tyler Robinson's case with the cross-examination of the State Bureau of Investigation guy, I'm like, God, why is she being such a bitch? It's like, so just the tone is not for everybody. It's not the calming, very, very polite approach of Mr. Burt. No, it's a little more of like it's a tone thing. It's a tone thing. I didn't like it. I just find it unnecessarily whiny, attacking, aggressive. I mean, the thing I've said before, and it bears repeating, I guess, is that you got to have multiple gears. Like the problem with a lot of defense attorneys is they treat everybody as the enemy. Everybody. It's like everybody who gets on the stand as a prosecution witness, whether they want to be there or not, it's like your job as a defense lawyer is to destroy this person and make them cry. Like, no, it's actually not. That's very rarely what your job should be. Your job is to get information from them that's helpful to your case. If they don't have any information that's helpful to your case, then you don't ask them any questions. Like, we need to see more trials where there's no questions from the defense. Like, this really is the better strategy a lot of the time. So treating everybody like the enemy just kind of makes you look like the problem. Doesn't it? It's that whole thing about, if you run into one asshole, you had a bad day. If you run into assholes, all day, then probably you're the asshole. It's like, that's kind of the same thing. If everybody on the stand you're treating like an enemy and like a bad guy, chances are probably pretty good you're the bad guy, and the jury is probably going to see you that way. So you need to have a gear, and that's what worries me about Kathy, is because I've seen for myself this tone issue. I've heard so much from other people about just the negative reaction and stuff. It makes me worried that it's too much of her gear. She doesn't have the ability to get out of that gear. And then, yes, that results in being very off-putting, and that can be detrimental to your clients. Well, like, why are you treating, if you put Tyler's parents on the stand, and it probably wouldn't be his parents just because, but you never know. I mean, You're treating them like they're public enemy number one. It's not going to go well. Put Erica on the stand and treat her like she's public enemy number one. Yeah, that's not going to go well. That's not going to go well. Mm-mm. Nope. Nope. You treat the victim of the crime with the respect, a lot of respect, whether you like it or not. So, I mean, I'm still lack sufficient information to have a strong opinion about Kathy one way or another, but I do know that she is a bit of a lightning rod for that reason. On paper, highly qualified, not to be underestimated, but not necessarily skill-wise in the same kind of ballpark as, at least from my perspective, I see so far from Mr. Burt and Mr. Novak. Well, guys, I'm going to call it an afternoon. Again, thanks for joining me spur of the moment. Sorry for the jump scare. Did something happen? No, nothing happened. I'm just filling time. So why not watch a 33-year-old closing argument to learn a little bit more? Or, maybe it will be helpful. Maybe it will not. Who knows? But it's something to give us a sense of Mr. Burt and what we can expect from him and the role he's going to play in the case. I like what I see. I'm happy. I think he's got a lot of skills that are going to be helpful, and definitely has the kind of background. I mean, you win the lottery. You win the lottery getting a lawyer with a background like that. So I will continue, based on what I have seen, to defer to the defense to tell me about the defense and when and if there are issues that should cause me concern, whether it be about production, whether it be about allegedly fabricated evidence. I am fully confident this defense team with these personnel, they are going to raise it. And not only are they going to raise it, they're the type of lawyers who will persistently raise it. Keep reminding, by the way, remember that time they did this, but it's coming. I see it coming. Frankly, they see it coming. There is a reason why it seems like common sense that the defense would love there being conspiracy theories and different approaches, different questions being asked and things like that about the case. You'd think that they would love that, because that would be generally making their jury pool more skeptical of their client's guilt. And that's generally what you want. So you'd think that they would like that. It would make some sense that they would like it. And yet they've made it crystal clear that they don't. They have distanced themselves from that. They called it on the record wacky conspiracy theories. Okay, they don't want anything to do with it. I think there's a lot of reasons for that. But very much one of them is because I suspect they can already see where it's going, which is that's going to turn around on them. That when reality, as it unfolds in the court, doesn't conform to the expectations that I think some people are developing for, big bombshell accusations and when that doesn't happen, where's the blame going to go? Is it going to go on, because maybe that shit doesn't actually exist, there isn't a basis for it? Or is it going to be these lawyers are to blame, they're part of the conspiracy, they're trying to get him convicted? Yeah, they know that's coming too. That's why they don't want anything to do with it. So, yeah. Not what I see. Not what I see at all. I see the kind of lawyers that anybody would be lucky. Anybody would be lucky to have in their corner. You know, even facing something significantly less serious than the charges that Tyler is facing. He's probably the most pleasant client they've had in a long time, just by virtue of being a relatively educated, you know, middle class kid with no criminal history. It's going to be quite unlike most of the people that they're used to dealing with on a day-to-day basis. You're going to notice it. It's gonna factor into your feelings about the case and your to some extent your strategies about the case. You fight harder for somebody that you like and that you sincerely believe in. And I don't mean like, oh, that means, you know, no, you don't like slack off and you don't raise things in your case for people you don't like. It's not at all what I'm saying. I'm saying when it comes down to, I'm giving up my weekends and I'm putting in the late nights and stuff like that because I am exploring every avenue. I'm doing that for the guy that I like. I'm not doing that for the shitbird who's over there trying not to masturbate during our visit. Okay. That guy gets the work, but he gets it on my normal time. You go above and beyond for the guy that you like. And so you know, I can envision that that's where they would be with this particular case. He's always been very respectful, you know, when they're on they do the camera, the introduction. Judge is very respectful to Tyler. Tyler is quiet. He behaves himself. When we were able to see, you know, the cameras and stuff, interacts well with the legal team. He's not like, you know, trying to corral Daryl Brooks or Shabusiness or anybody like that, which is a vast proportion of the clients that these guys normally deal with. This is like a breath of fresh air for them. So no, they've made careers out of fighting these fights. They do it because they believe in it. They have a strong incentive in this particular case to clear the field, go above and beyond. So until something happens, there's some like actual evidence of a problem, some kind of breakdown or some kind of non-performance or something like that. Yeah. I'm not buying a, you know, attorneys don't care about Tyler. Attorneys are trying to throw him under the bus, something like that. No. I think you need to not know anything about the kind of people that you're dealing with to think that's remotely plausible in this kind of scenario. You don't spend 50 years in the public defense trenches just so that you can throw some guy under the bus. Not happening. Just my opinion, of course, but we'll see how all this plays out as usual. So yeah, we're still waiting to come back to court. We got court the 19th, just under a week. We'll be back in court. Probably going to have, if not a full day, you know, a good chunk of a day for the motion hearing. A little bit up in the air still what they're considering, but the primary thing is going to be that request to hold Chris Ballard in contempt. So might be worth, maybe, I don't know, if we keep having this wind, maybe I'll get live and we'll read through some of that or something. We got some options, but if nothing else, we can expect to be back in court next Tuesday. And it's an early one. It's 9 o'clock Mountain. So that means my time Pacific. I'll be going live probably about 7:45. Make sure we catch the whole thing. And otherwise, guys, I hope y'all are doing well. I hope y'all are getting a little spring, getting maybe even a little summer. I felt so bad. Yesterday we had such a beautiful day. I was out on the paddleboard, posting the paddleboard. And I'm hearing from people like, other parts of the country that are still in their puffers and stuff. Not really enjoying the warmth that I got to have yesterday, but it is coming, everybody. It is coming. There is one thing that is certain, it is that time will continue to pass. Day will continue to follow the next. And days will be getting longer and so forth. Alex Murdaugh gets a new trial. That was the news of the day. Yeah. So this had been rumored for a long time. I was kind of expecting it. And I think largely just based on the oral argument that they had in the Supreme Court. It was a while back now. I think it was last year. I want to say it was last fall sometime, but I can't remember exactly. Kind of saw that it was coming, and Becky Hill getting that conviction for perjury definitely didn't help. That happened, obviously after his trial and his first appeal. So wait, am I remembering that right? No, I don't think he did have a first appeal. Anyway, it happened well after his trial. It happened after the motion that was brought up, of course. So anyway, that didn't help. That featured in the decision as well. The fact that she got convicted of perjury, not particularly helpful. Old Becky Hill, as it turns out. So he is going to get a new trial. Don't really know timeline wise when that's going to be. This decision is coming out of the South Carolina Supreme Court. And so there really isn't anywhere higher to go. I mean, yes, I suppose in theory, the prosecution could ask for certiorari to the U.S. Supreme Court, but not likely they're going to get it. And it's probably turns on state law for the most part anyway. So doesn't typically stay anything too if you try to go up to the U.S. Supreme Court on a direct appeal. So there being like no higher recourse in South Carolina, the appeal is probably going to be final pretty quick, and they send it back down to the trial court, and the trial court's like, in theory, they've already litigated everything. It's ready to go, right? They just need to get everybody's schedule coordinated and bring them in and pick another jury. So it should happen pretty fast. I mean, could be within a couple few months, but we'll have to see. So I didn't watch the first trial. I was still like full time up to my eyeballs in the public defense trenches myself when that trial was happening. So I only caught the little bits and pieces, and I do think it would be interesting to watch the whole thing. Just not really knowing a whole lot. I'll tell you what I know about it. Here's what I know about it. At least what I remember, and I could be remembering wrong. So let me know if I am. What I remember is that he testified against the advice of his counsel. I remember there being this colloquy on the record where the defense lawyer like made a whole thing about explaining he's exercising his right to testify against the advice of counsel. Really wanted that on the record. And as it turns out, like probably for good reason, because it seems that Alex Murdaugh did not do very well on the stand. But the other thing I remember about it was just the Snapchat. And I don't even remember a whole ton of the details other than that he was not supposed to be at the barn when this was happening. The Snapchat was like within, I want to say, minutes of the murder. He's not supposed to be there at all. He's denied being there. And then there's a Snapchat from the son's account that's got his voice on it. So like he's there. That was real bad. That was a real bad piece of evidence. And it, you know, from my perspective, the defense lawyer, not enough to put a gun in his hand and be like, yeah, so then he did a shooting. But obviously he's got major credibility problems. You can't believe what he said. And he obviously just knows a lot more than he's communicating. And so, you know, I can see, even though legally debatable, you know, beyond a reasonable doubt and all that, legally debatable if that makes him guilty of murder or not. I can see where the jury would have been at the point of like, frankly, don't even care that much, because can't take his word for anything, and he's there where he's not supposed to be. And if he's there and doesn't have, you know, things to say that we can rely on that are exonerating to him, doesn't have a really good explanation for how he wasn't involved in the murders that took place minutes later, then guess he's guilty. So I don't know. I mean, I don't know. That's literally about all I know about it. I know generally about the motive stuff, you know, that he was like, he claimed he was it Oxy, like he claimed opioid addiction and got him in all kinds of financial trouble, and he was stealing from clients and things like that. And so I'm like aware of that generally. They mentioned it in the opinion. They talked about how there's basically like it's relevant to prove motive, but the state went way overboard with how they presented it and how much they presented it. And they gave a little excerpt that I'm like, oh yeah, okay, I get it. Where they're talking about him like taking a settlement from one of his clients, and the client is a special needs individual. And so they repeat that like 3 times. Can you say that again? So you're saying he's a special needs, like just to literally emphasize that this guy is vulnerable. It has nothing to do with Alex Murdaugh's motive, right? It's just to make him look like a bad guy because he took advantage and you know, betrayed this special needs guy. So it sounds like they're going to have a much shorter leash on the financial crimes stuff the second time around, but it is still going to be allowed generally as proof of motive. So we'll have to see. But I do remember that being kind of the crux of the issue of like, well, it doesn't seem like anybody ever really put a gun in his hand, but obviously he's much closer to this murder than he wants us to think, and that it really seems plausible that an innocent person would be. So I am kind of eager to see that and how that works out. So I will probably watch that the second time, although I'm never going to make any promises, especially during the summer, guys, because summer is the time to be outside. I just got a new backpack. I'm so excited. I got a bigger backpack. I got a 58-liter pack now. So I've been stuck on about a 3-day max limit, just because with my old pack, that's about the much food I can carry with all my other stuff. But now I got like another almost 20 liters. Yeah, I can carry some food. So might be able to do some good treks this summer. And that's gonna take priority over a trial for me, more than likely, especially if it's particularly hot and miserable down here, and need to get away, need to get up into the high country. All right, guys, I keep saying I'm going to check out, and then I don't, but now I really am. I got a Phillies game to go check on. I got to see if Andrew Painter is getting shelled. Oh man. And then here you guys are continuing to keep me here. Harbinger of imminent death. Is the prosecution under any obligation to discuss a deal with a defendant who's open to it if they think they have a strong case and want the max? Absolutely no obligation to offer a plea deal. There is no constitutional right to plea bargaining. They don't have to offer anything. And to me, that's really the $1 million question in Tyler's case. Again, given that there's still so much we don't know about the evidence and how strong it is and so forth. Nevertheless, looks reasonably likely to me that a conviction is a probable outcome here. Again, the benefit of the doubts on the evidence and that the state's going to be able to deliver on what they say they have in most material ways. That's really the question. If conviction is likely, you've got a strong incentive. You, the defendant, have a strong incentive to take a deal. But they don't have to offer one, and so that's the other side of the coin. They think they're going to be able to get a conviction either way. They're not necessarily going to offer you anything. And so if they don't take death on the table, there's no plea bargaining. There's no plea. That's what it's going to come down to, I think, is will the prosecution take death off the table? If they will, then I think there's a very decent chance they get a plea. Probably not right off the bat. Just depends on how things are structured. But defense is gonna delay, they're gonna want to litigate as much as they can in the hopes that it can improve their position, right? If I win a suppression motion and something gets tossed, now your chances of conviction are lower. Now I have better leverage for a deal. Or I'll just go to trial. I have a stronger case at trial now. So the defense's incentive is to litigate the case as long as they can until, push comes to shove and you got to decide, plead or go to trial. The prosecution can put some kind of restraints on that by saying, okay, I'll give you an offer, but it's got a deadline. You're going to have to decide within the next 2 weeks, the next 30 days, whatever it is, but just take that litigation opportunity away from the defense. And they're allowed to do that because there's no constitutional right to get an offer at all. As long as probable cause supports the initial charge, you have a limited right to plead guilty to that charge at your arraignment. And then after that, you may not have that right anymore. So no obligation to offer anything at all. It is an Osprey, but I don't remember the model. It's a 58 liter, women's 58 liter. I don't remember what the model is named. It's a good pack. I like it. So I take a small pack, like I'm 5'10", but I take a small pack. I didn't really realize this for a long time because I have a short torso. My height is all leg. And so I most of the time, like finding a good big backpack is just not going to happen because it doesn't fit me well. And that means the top, like my head is going to be banging into the top of it and stuff like that because the frame doesn't sit right and everything. This one is perfect. It's perfect. I just love it so much. I can't wait to test it out. But on a less windy day, the wind will turn it into a sail. Plenty of wind in Patagonia to test that out. So what is this one? Osprey Pack Stratos 36 backpack. Mine isn't the 36. If you have the 36, it's probably a good pack if it's an Osprey. I really do like the Osprey. One of my favorite things about it is they give you the cover, the pack cover. Like they all come with the rain cover. It's a nice little bonus because it fits. You don't have to buy like the generic rain cover that isn't really sized to your particular one. And so it's like lumpy over here and tight here. And this part, scooches out and the rain gets in. Like they give you a rain cover. It's a very small thing, but important. And I like it. Very much appreciate it. All right, guys. Calling it good. Calling it a day. I do appreciate you all coming in to keep me company and chat about stuff. Taking a little old school, little back in the day legal action. But as much as things change, right? He will not be struggling with the poster board in the Tyler Robinson case. Things very much do remain the same in the courtroom, the basic structure and function. Don't expect him to change his stripes an awful lot. He's figured out a system that works, and when you have that, you might as well stick with it. So, guys, I will see you next Tuesday, if not sooner, for the next Tyler Robinson hearing. You know what to do as far as the things. I've got the Substack to go check the legal documents, which I will check the docket too this afternoon, see if we've got anything new filed. Notifications and all that. You know the things. So if I do decide to do another impromptu live, that's how you will find out. It will be impromptu. There will be a notification thing of some kind. And hopefully, if that happens, I would love to see you all there. But in the meantime, again, thank you all. Thank you all for joining. Very much appreciate you. Thank you, mods, for being like, sure, let me drop everything on extremely short notice and just come hang out to watch a 33-year-old closing argument. You guys are the best. I really do appreciate you all so much. My husband, who had to take a break to go to his own court hearing and still made it back. Thank you guys. Appreciate the chat. Go Phillies. Go Phillies. We'll see you guys next time.